to
or judgment, item number 1, SLL 14 of 2009.
In view of the foregoing discussions, we are of the view that the conviction of the appellant under section 302 and 324 of the IPC and the sentence imposed thereafter by the London trial court is quite justified, and we find no illegality or infirmity to interfere with the same. Accordingly, the impugned judgment of the London trial court stands confirmed. In the result, the JCLLA stands dismissed.
I agree.
pardon to make a mention, Your Lordship. Item number 39, Your Lordship. Your Lordship, one prayer is if the matter not reaches, kindly take up this matter as last item of the day.
Proceed, please.
Deeply obliged, Your Lordship.
Supplementary list, item number 2.
Wait, please, Lordship. Lordship, as per the Lordship's order, my lord, we have already filed the IA for amendment, which is at flag D of your Lordships today. It's a
Copy may
formal-
be served, my lords.
Already served, my lord. Copy has been served on the state, my lord, but I'm anyways giving another copy right to him. Form, we've already filed it, no? We have the receipt.
Right.
My lord.
There is an interim application.
My lord, for amendment at flag D of your Lordship. Flag D. That's the noting, my lord. IA number 15702. Yeah, my lord, we have at Annexure 29, page 18.
Challenging that Annexure 29 and some grounds have been taken.
Grateful, my lord.
So please go through it, Mr. Why didn't you supply it earlier?
My lord, we have given it and
Received a
we
copy.
filed.
These are formal amendments. I'll go through them.
Okay. Can it be taken up next week or week after?
Well, it's next week itself.
Next week.
Because my lord, there's an interim order.
Yes, no, if you want, it can be taken up tomorrow. There is no.
Yes, my lords, tomorrow.
All right.
My lord, my only prayer is, my lord, tomorrow I can file the consolidated writ petition if it's allowed. If they have no problem, I can.
we'll see. Let him go.
Because, my lord, anyways, I have to file the
IA
consolidated.
number 15702 of 2024 is an application for amendment. The copy of the interim application is served on the line. Counsel for the state in court today.
Well, it is also filed, man. It is also filed in registry.
So it is stated that copy has already been filed earlier in the AG office. The land counsel for the state sets time till tomorrow.
My lords.
Go through the interim
My lord.
application and if necessary to file objection.
My lord.
Put up this matter on 27th November 2020.
My lord.
Tomorrow is 27th.
Obliged.
The interim order is there, no?
Yes, ma'am. Let me continue.
Interim order dated so on so is extended till tomorrow.
Grateful. Deeply
Okay.
obliged.
Item number 3. Item 4.
May I please address it? Here is a petitioner is a masjid matter pay for the renewal of their renewal of the lease land matter, which is pending since 2003. Under Annexure 10, we have applied, and under Annexure 11, they have started a OGLS miss case number 29 of 2003 that is still pending.
What is the case number?
Case number is 29 of 2003. OGLS case, Annexure 11 at page 27, matter.
29
of 29.
2003. It is still pending.
Still pending, matter.
No. When was it? When was the lease granted?
Lease granted much prior to that. It was earlier expired in 69. We have filed it again by under Annexure 9. Matter page 24.
Yes.
The Tahsilar directed to file a fresh application.
Yes.
So we have filed again in 2003.
The prayer in that Annexure 10, which is your petition,
Matter.
that is perhaps at page 26,
Matter.
that the Schedule A land may kindly be ordered to be settled permanently in favor of the petitioner, and ROR may kindly be issued, and for which one so this has been given. So on the basis of your petition, that OGLS miscase has been
Initiated.
registered, that is 29 of 2003.
Matter.
And till what date you have given your order sheet? How can you know that it is still pending?
Your last order sheet is of 20th.
So I will apply for the certified
August
copy. 2 weeks time may be granted to me to file the total order sheet, matter.
The writ petition has been filed by the petitioner, Partan Masjid. The name of a person or what?
No, this is a
Partan Masjid, Pension Pada.
Pension Pada.
Pension Pada, Sambalpur town. Represented through its Mutwali, bracket listen to President Managing Committee. With a prayer for a direction to the opposite party to renew such and such. The London Council for the petitioner submits that the petitioner preferred OGLS miscase number 29 of 2003 before the Tahsildar Sadar Sambalpur under section 4 of the OGLS Act with a prayer for settling Schedule A land permanently in his favor and for issuance of ROR. However, even though in the meantime 21 years have passed, but no final decision has been taken in the said case, the London Council for the petitioner has annexed the order sheet of the said case as Annexure 1. However, it appears that it is only up to 28/2004. The Land Council for the petitioner seeks some time to obtain the entire order sheet of the said miscase, and for such purpose request 2 weeks time. This matter in recommencing from such answer. Yes.
Item number 5.
May appeal lots. Sir, 7 minutes. Page 62.
Yes, yes.
I'm challenging.
Achha, Mr. Bose on that day appeared and submitted that he has already appeared for OP3 and filed Ginama, and you are required to serve a copy of the repetition. Okay. No, in this case, notice has not yet been issued. No. So, what is your prayer in this petition?
Writ petition to quash the Annexure 7 minute. That's the 8 phase 62. And that's the appeal has been filed by the OP number 3. And that's the appeal before the sub collector. And where the sub collector has confirmed the approved the order of the Tahsildar. Tahsildar has submitted the entire record and which has been approved as per the rule. And the OP number 3 filed.
No, you come to the that impugned order.
Yes, ma'am.
Now, that is Annexure 7.
Yes, ma'am. Annexure 7, page 62, ma'am.
Right. And
I have taken ground that the objection, the maintainability, ma'am. That's not considered, ma'am, in the impugned order. Because the order has been approved by the sub collector, and
no,
sub collector has
from page number 65.
Yes, ma'am.
There was an earlier petition before this court, that is WPC number 32156 of 23, which was disposed of on 19/10/23.
That's by OP number 3, ma'am. And to dispose of the
connection with this particular case,
yes, ma'am.
And there was a direction issued for disposal of misappeal number 1 of 2021.
Yes, ma'am.
And apart from that,
Another
writ was also filed to dispose of the representation of the petitioner and pass. So
that's why that's
mentioned in that. Please read out the last 2 paragraphs.
Yes, ma'am. On appreciation of the record, it is manifest that all legal heirs of the late Mansram Agrawal were not made parties to the proceeding of the lower court, which is known as after the death of Mansram Agrawal, his successor in interest should have been made necessary parties to the proceeding, and in their absence, the Lord Tahsildar cannot pass any order in favor of the applicant Shankarlal Agrawal. In above premises, the case record is remanded back to the lower court to fresh adjudication, and the lower court is directed to implead all legal heirs of late Mansram Agrawal as parties to this case and issue them individual notices, and after giving them an opportunity of hearing, pass final order according to provisions of OGLS Act 1962. According the matter is disposed of, on observation as matter above. My lordship, my objection was there that the maintainability of the.
Why did you prefer read? There is an appellate provision.
No.
Appeal provision is there.
No, that's the appeal.
No. Against the order of sub collector, there is an appellate authority.
But my grievance.
Again, there is a revisional authority. So there is a procedure in the OGLS Act itself.
No, there is no.
Why are you coming in read?
No, that's the appeal is the final below.
No. You see, section 7.
The revision before the RDC.
No,
revision before the RDC is there.
Yes, my grievance, Lord. My objection was not considered
Whatever
there.
it is.
And
whatever.
That's the without jurisdiction.
An order
because they
rightly, wrongly, whatever. You have a provision in the act. How can you come and read in between?
Since the order is without jurisdiction,
No. If it is without jurisdiction, yes, authority can take it.
No, this,
Appellate authority can
that's without jurisdiction and my objection was not considered.
All right.
That's why
Anyway,
it can be
this is
maintainable
an
as per
order
the
passed
whole
by
case.
This is an order passed by the authority.
Yes, ma'am.
And there is a provision for revision for appeal. Whether you can come in between.
No. Since the appellate order and that's without jurisdiction, that's why I'm before the writ court, my lord, as per the whole case.
The question that is posed to you that whether such point cannot be taken before the revisional authority,
No, that's before the appellate authority.
bypassing a forum and coming straight to the High Court.
Yes, that's
the exact question. Which
yes. I'm saying, Lord, that since
are you
my
disputing that against the impugned order, the revision is maintainable? Are you disputing that proposition?
No.
Then
I'm not. Since I am saying, since
avail that opportunity and then come.
No.
Heard the learned counsel for the petitioner and counsel for the state. The petitioner, Sankarlal Agrawala, has filed this writ petition challenging the order dated 12/7/2021 passed by the Lease Appeal number 1 of 2021 by the sub-collector Lagar. The learned counsel for the petitioner seeks permission to withdraw the writ petition to appeal to approve the revisional authority.
My lords, I'm so sorry, my lords.
Appeal.
Appeal.
Appeal is there. Collector is there. Collector appeal is there next. Then revision.
no,
So there are
since that's the appeal, that revision will be liable. Since that's the appeal, and
this is also appeal and that is also appeal. Here is a difference in it.
Right.
After the order of sub-collector, it is again before. There are two appeal provisions.
The appellate authority also and if necessary the revisional authority.
Yes.
Accordingly, the writ petition is disposed of. Yes.
So delay, also limitation question may be considered.
Any application is filed for conversion between filing the appeal, the same shall be taken into account after hearing the learned counsel for the party in accordance with law. Yes.
Yes.
Item number 6.
May well, the fact of the case is that the petitioner has approached for compensation, even though his land has been acquired and approaching road has been made in a breach.
When the land was acquired,
My lords,
when the land was acquired,
when land acquired into 21-22, they have acquired the land, they have constructed the construction is over.
you have submitted leader notice.
Yes, I have sent
So,
legal.
any response has been received?
Yes, they have received, but they have not given any reply to that. My lord.
No.
Page 9 may kindly see. Page 9.
We are asking you that have you received any response from the other side?
No minutes, nothing. So that is why I have
So,
approached you.
Mr. Naik, let it be
My
treated as representation and disposed.
My lords. Obliged.
Are the land counsel for the petition, land counsel for the state. The writ petitioner, Navagana Shah, has filed this petition with a preamble with direction to the opposite party to pay appropriate compensations either on negotiation or by a land acquisition proceeding. And for imposition of penalty and cost of litigation for harassment of the petitioner depriving him from his legitimate right. The land counsel for the petitioner submitted that legal notice has been served on opposite parties on 4 by annexure 1 on which was sent by registered post, no? Registered 4, and it has been received by the authority. Representation legal notice dated for the 1/4/2020, but he has not received any communication from the concerned authority, and the authorities may be directed to take necessary action on such notice. the land counsel for the state submits that he has no objection with the said pleader notice is um, taken as the representation of the petitioner, and the authority will deal with the same in accordance with considering the submission made by the land counsel for the respective parties. The before which opposite party number two or what?
No, opposite four will be
Who is the appropriate authority?
operator.
You have made represented to all of them, 2, 3, and 4.
Yes.
So which would be better? 2. All right. Let the opposite party number 2 treat this pleader's notice dated so and so as the representation of the petition and consider the same and uh, dispose of the same within 3 months. And from the date of production of the certified copy of this order along with a copy of the writ petition and communicate the order to the petitioner within 2 weeks. If it is necessary, then personal hearing shall be afforded to the petitioner. Accordingly, the writ petition is displayed. So, yes.
I had another petition which had
Yes, 7 and 8.
7 and 8. No, we disposed of item number 6 now.
Yes,
6 and 7.
but that is that is not listed. I pay that it listed tomorrow.
Another one.
What is the number? No, what is the number?
Number 7110.
Why are you not filing a memo, Mr.
Yes.
Patnaik? Just give a memo to the.
I'll give it to him.
Just give it. It will be listed tomorrow. Yes.
Item number 7.
I am for the petition. So it called for a report from the Deputy Court Tribunal that is
Also, how the disposition directing to pronounce the final order 13/11/2020 on council funds concluded on 2/2/2024 and posted to Swansea for delivery of order, and thereafter several dates were passed for such purpose. The final order has not yet been pronounced, even though the date for such purpose was fixed to 13/11/20. On the report from the
reported flag game.
5/2024 जजमेंट ପାଇଁ ହେଲା ଦେଖନ୍ତୁ the report of the land register DRT pattern which shows that SA number so and so is listed on 5/12/2024 for judgment. In view of such written communication received, no further orders is required to be passed in this writ petition. Accordingly, the writ petition is disposed of. Yes.
7 and 8.
8 also same.
Same it is posted to 4th minor. 4th
All right,
for December.
disposed of. Same. 8 number था, है ना?
The item number 8 is I am appealing for the ban. I have filed for
अच्छा item number 8 रे
8.
तारिणी प्रसाद नंदो देखा
BK Behra and Sarani
अच्छा अच्छा all right hard Mr. BK Behra for them land council appearing for the banks
opposite party 2 and
opposite party number 2 all right yes next
Item 9.
May I proceed? Well, the petition land has been acquired in Manjari irrigation matter in the register of Hon'Ble manner.
so representation is annexure 14
Pending since 2020.
Depends on yes, my lord.
2000
12/12/22.
22
My lord.
you have not received any communication from the authority.
No, my lord.
All right. Annexure 14 to be disposed of 3 months from the date of production of the certified copy. 15 days it is to be communicated. All right. Next.
Annexure 19, sorry, item 19 also same, my lord.
19.
19, my lord.
And item number 19 also same. Same annexure.
Same annexure.
Oh,
Within a specified time.
yes.
Public.
Item number 10.
May I please your lordship? That the petitioner is a senior typist in the under the district and sessions judge Nuapada Mela, and for promotion he has filed my lord to the rank of superintendent. And while the reprehension was pending, he has filed this case annexer 17, the reprehension, my lord. In the meantime, my lord, just 5 days back, on 16/11/2024, the reprehension was rejected by the OP number 3, so permitted to file a fresh liberty to fresh, my lord.
The Grand Counsel for the the petitioner has filed this so and so has filed this writ petition for a direction to the opposite party number 3 for considering his case for giving him promotion to the rank of superintendent bracketed type bracket end comma level 2 as per the unamended provisions of Rule 2008, with granting all consequential service and financial benefit within a time-bound period. It appears that the petitioner has submitted a representation
Annexer
before
17.
the London District Judge Nuapada for consideration of his grievance, and the representation is dated 26/7/2024. Grand Counsel for the petitioner submitted that the petitioner has received communication from the London District Judge Nuapada that his representation has been rejected, and therefore he intends to withdraw this petition to file.
Appellate authority. Go to the appellate authority. There is
you
an
have-
appellate authority.
There is an affiliate authority.
He need not come here.
You want
Rules.
High Court committee. is there.
High Court committee achieve, you can challenge that representation and also consider. He wants to avail the appellate forum, appellate authority.
Appellate
According to
rule.
the petition,
I will examine. Another
Another
writ is shall I
ଗୋଟେ।
give memo? ଦୁଇଟା ଫାଇଲ କରିଥିଲି, ଗୋଟେ ଆସିଛି ଆଉ ଗୋଟେ କାଲି ମେମୋ
ଦେଇଦିଅନ୍ତୁ, ମେମୋଟା ଦେଇଦେଲେ ପଳେଇ ଆସିବ କାଲି।
Item 11.
Case of a initial appointed Delhi laborer in the Survey of India office challenging the order passed by the Central Administrative Tribunal. But his appointment was in 1997. But kindly imagine now, meanwhile, 27 years have passed. 27 years since 97. But he wanted regularization. Prior to that, he had approached the tribunal for consideration. Tribunal directed for consideration.
Which
Page
order you are challenging?
No, I am challenging Annexure 1. Lord, precise ground, page 24 is the ordering part. If Lordship would kindly turn to that.
Mr. Pari, please unmute yourself.
Yes, my lord.
You have received the copy of the writ petition?
Yes, we received the copy of the report. As I is the party, yes.
Right. Now, your Lordship would kindly turn to page 24. The ground on which my petition is rejected by the London Tribunal is, Lord, though referred to ML Kesar and others, they have said that not through any proceedings, as per rules, nor against any sanction post, question of his regulation on the strength of DOPT 2000 doesn't arise. But my first point is, if Lordship see, identically placed persons, they had approached the Central Tribunal Jammu Kashmir 26 persons. The similarly placed persons, state government has obeyed that judgment and regularized. And that's a point I have taken. It's a case of discrimination.
State government of Jammu Kashmir.
Jammu Kashmir. Under the same Survey of India organization, similarly placed 26 persons. The order passed by the Jammu Kashmir Tribunal is at page 57, 56. But the judgment is here, and the Union of India has complied with this judgment without rejecting their case. But my contention is, when you are complying with in case of similarly placed persons, and that order of this government, Union of India is page 67, madam. Kindly see. Page 67. 21 persons they have regularized, identically placed. Now, so far me is concerned, learned tribunal without considering this aspect rejected my case. That is one. Two, if your lordship will see Umadevi para 12, Lord, these are the cases prior to Umadevi, those who are appointed, the Umadevi's case has given a relaxation for them, para 12 of that judgment, Lord, that is there. I'll cite that also. So, if your lordship will consider as a wholesome and points raised here, Lord, the order passed by the learned
No, if it is not against a sanction post or the it is a backdoor method, it has been adopted. What is the that particular paragraph state?
para 12, Umadevi para 12. In fact, the judgment my learned friend has not got it.
So that is only to be distinguished on account of illegality or irregularity.
Irregularity.
These are the two aspects to be seen in Umadevi.
Irregularity. But para 12 is a case if the learned your lordship see even on sanction. Para 12 is the ratio there. But that can be taken into consideration. The learned tribunal below has not considered that part of the case. And if your lordship sees, they have failed. Lord, we have been given certain status. Lord, I was initially a DLR.
Yes, Mr. Farin.
Yes, my lord.
ଆଉ କେତେ ବର୍ଷ କାମ କରିବ ସିଏ ଆପଣ ପାଖରେ?
My lord, again, it is a ASI, Archaeological Survey of India, and in this organization, these people are engaged time by time to the independent work. Suppose the Jagannath Temple work will come, we have had some peoples. We will take the
Yes,
expedition.
you say that it is on the basis of the project work.
Project work, yes.
Once the project goes, the people go.
Whose the work is goes.
But if you have a perennial nature of job and they have been engaged continuously, how can you say? You let them off when the project is over. You let them off and get some new people.
There are, if similar nature of work we are getting, we are also engaged some people for that work. Or taking the service, we are paying the same. No. It is not that it is a permanent in nature.
Only you are depriving them from their legitimate dues. Otherwise, you are taking their service all through for 27 years.
People are there. Those are working not only with us, they are working various places.
No, that we understand. But what made you to continue with these people? You could have taken new people when there is a new project. New people could have come.
We have a contractual work. Those contractor is engaging. It is not that we are engaging. This contractor is engaging the people with us.
The point raised by Mr. Padhi, straightway answer is page 25, my lords, may kindly see. These are all based on, kindly see page 25. Lord, they have uplifted me from casual to group D. They have already uplifted me in 2009. Kindly see page 25. There is no whisper about any project or any temporary or requirement or work basis, nothing. Kindly see 22/6/2009, page 25. In portions of office memorandum dated so and so, subsequent number so and so regarding recruitment of casual workers, the following casual laborers working under this circle completed 240 days in a year and performing their similar nature of job of group D will be paid wages so and so. The workman will discharge duty with utmost so and so. My name is Jitendra Das.
But this petition has been filed by the petitioner, Jitendra Das, who is at present working as a casual worker at Archaeological Survey of India Circle Office, Gopinathpur, Samarkata. Filed this petition challenging the order dated 13/9/2024 passed by the Central Administrative Tribunal Cuttack, bench Cuttack in OA number 260 oblique 00507 of 2023. In dismissing the original application, which was filed with a prayer for the regularization of service. Regularization.
This same person is filing one after litigation. It is continuous process. Even though he is not working with us, what instruction?
Relief not there,
come first time.
Land Council for the petitioner submits that the petitioner has already completed 26 year service. No?
26.
26 year service. And Annexure 2, which is dated 22/6/2009, would reveal that he has been placed in Group D scale of pay. Current counsel, Mr. Ari has already accepted the being served with a copy of the petition. Issue notice on the question of admission indicating therein that the matters of petition at the stage of admission. 4 weeks after, counter affidavit is being filed.
2 extra copy में sir
Extra copies of these also will start on the land council copy. His name shall be reflected along with
with Mr. Maharana, B. Maharana.
B for Hon'Ble, B.
Vishwajit Maharana. Vishwajit Maharana.
Vishwajit Maharana.
And she. Oblige.
I take a little more liberty, my lord. Item 20 is another same person. Similarly placed. Yes, same.
20.
Item 20. Rabindra Kumar Silly.
Silly.
Silly. Same.
ताको पिटा नहीं था पर
line output here. Mr. Similarly situated person. Of course, the Central Administrative Tribunal.
Same.
Kashmir, no?
I'm referring to Jammu Kashmir,
No.
but here is the Cuttack bench.
No, the Aratari.
The Jammu Kashmir.
Jammu Kashmir. And the employees which was accepted by the Union of India and the employees who
26. 21.
21.
their services are item number 11.
well this item 20 SS Kashyap name
item 20 रे SS Kashyap बना लेते है ना आगे ये लाइन का ऐड करिए
In place of 21 should be 31.
31. Yes, next.
Grateful.
Oblige.
12.
They have acquired the lands of all the villagers. And so far the compensation concerned, they have not paid the compensation as per the scheme. I have ventilated my grievance also.
Representation किसी सुनी ना
Annexure 9, 9.
Annexure 9 to be disposed of on the date of 3 months from the date of production of the certified copy and result thereof to be communicated within 2 weeks. Yes, next.
Item 13.
So last.
Lordship, let us come to page 15. Initially, the present petitioner preferred the application before this one. After going through the your lordship directed for disposal of the that is the representation of the present petitioner, which has been pending for the collector, my lord. That after acquiring the land, my lord, neither they have paid any compensation, nor they have followed the principle of RR policy.
We are asking you, Mr. Das, you earlier approved this court
and
the petition,
and
the order was passed on 12/3/2024.
My lord.
And in the operative portion at page number 16,
my lord,
the direction was issued to
opposite part
number 2 to consider and dispose of the representation
Annexure 1
within 3 months.
3 months. Till today, they have not disposed of. They have like that the representation is lying before the collector.
So you obtain instruction why the representation has not been disposed of, why communication has not been made. All right. The Land and Council for the petitioner submits that the petitioner earlier approached this court for a direction to the opposite party to extend benefit of rehabilitation and resettlement in his favor. And in that connection, he had filed a representation before the opposite party number 2, collector and district magistrate on board. When he approached this court in WPC number such and such, by order dated 12/3/2024, the writ petition was disposed of with a direction to the opposite party number 2 to consider and dispose of the representation and to pass order as early as possible within a period of 3 months from the date of production of the certified copy of the order. You have produced the certified
My lord, that is
it
annexed section.
submitted that even though the certified copy of the order was produced before the opposite party number 2 and the time stipulated by this court has already expired, but the petitioner has not yet received any communication from the opposite party number 2. Stop. Let the land counsel for the state obtain instruction about the status of representation this matter in the week commencing from 9th December 2024. Obliged.
Item number 14.
May I please, your lordship? My lord, petitioner challenge the impugned order under Annexure 4, that is order dated 20/2024 passed by the learned first additional senior civil judge Berhampur in execution proceeding number 72 of 2005 arising out of a land acquisition reference number 3 of 2022. My lord, in that impugned order, the learned civil judge senior division approved the calculation sheet and directed to pay an amount of 63,99,866. Well, earlier the learned court below has calculated an amount of 74 lakhs, which was corrected by the impugned order, but the learned civil judge has not taken into consideration that the present land acquisition reference, there are 3 land acquisition reference, there is a common judgment, and against the common judgment there are 3 land acquisition appeal, which now 2 land acquisition appeal are pending before this honorable court, and one is disposed of by the National Loko Adalat of this honorable court, my lord, and pursuant to the disposal of that appeal, the present execution proceeding, my lord. My lord, the petitioner has, the beneficiary, the Berhampur Development Authority, has filed an application that since there are 2 land acquisition appeal still pending, and there is a scope for variation of that impugned award, my lord, the market value of the land, and there are other circumstances. My lord, the petitioner filed an application for variation of that still stay till the outcome of that 2 appeals, my lord. Well, there are other aspects also which the petitioner challenged in the execution proceeding, my lord, but the learned trial court has not considered those aspects. Only mechanically approved the calculation sheet submitted by the decree holder.
This particular matter has been disposed of in the local.
Yes, so far as the present reference case is
the amount, but he can
you deposit that amount and
my lord, pursuant to the order of this honorable court, the petitioner has already deposited 1 crore something, and the which has they have also withdrawn. By order of,
out of that 1 crore, obviously this amount would go this 63,99,866.
This is included.
No,
this is
excluding that amount, the claimant will entitle this much amount as they claim. My respectable submission, since there are 2 other appeal are pending before this honorable court, and there is every possibility that the court may vary.
No. Why are you not taking steps for the local adalat is there in the 2nd week of December?
My lord.
So those 2 appeals can be listed in the local adalat.
My lord.
Why don't you file memo?
My lord, I will take a step.
The order will be passed and it will be listed. Why this order will be varied? What is the purpose? If 2 more appeals are passed, that can be disposed of in the next local adalat. We withdraw this petition. There is no.
My lord, petitioner will withdraw the present writ petition with a liberty to file an appropriate application before the.
Are you stopped? Are you stopped?
No.
If you are stopped, then only you are not stopped.
The learned counsel for the petitioner, after arguing for some time, the learned counsel for the petitioner seeks permission to withdraw the petition, disposed of as withdrawn. Yes, next.
Obliged.
Item 15. May I please, your lordship? Your Lordship, I'm challenging the order of the Honorable Central Administrative Tribunal, Cuttack Bench, Cuttack, Your Lordship, wherein the prayer of the petitioner challenging the punishment order has been dismissed, Your Lordship. On the last occasion, your Lordship had granted me liberty to assist Your Lordship by presenting some case laws regarding when the tribunal and the court can interfere in a punishment when it is shockingly disproportionate.
No,
Your Lordship.
is that the only charge against you?
No, Your
That you
Lordship,
deposited the on the next day, on that was on the three occasion, as it appears.
Yes, Your
You
Lordship.
received the money and you did not deposit on the very day. You deposited on the next day. That is one thing, but
There are
is it
several charges.
there is the only? It's not the only charge.
There are total 5 articles of charges, Your
Yeah.
Lordship. First is that when I received it, I remitted it the next day, Your Lordship.
That is
Okay, that is all right.
What are the other charges against you?
Your Lordship, there is another charge in which it has been stated that I was asked by another branch officer, Your Lordship, to open a term deposit account, and I did not credit the account immediately. I credited it after few days.
You received the money.
Yes, Your Lordship. And to that effect, the petitioner had given accounted for the delay, Your Lordship, by stating that there was some discrepancy regarding the signature of the applicant. As a result, it was returned to the concerned branch officer, and after receiving the proper signature, the amount was credited, Your Lordship. The petitioner, Your Lordship, has accounted for the delay in each and every case. In each and every case, there is a delay.
No, ଆପଣ ପାଖରେ ପବ୍ଲିକ ଆଣିକି ଟଙ୍କା ଡିପୋଜିଟ କରିଦେବେ, ତାପରେ ଆପଣ ସେଠୁ ଆପଣଙ୍କ ଝିଅ ବାହାଘରରେ ଖର୍ଚ୍ଚ କରିଦେବେ, 2 ମାସ ପରେ ଆଣିକି ଟଙ୍କାଟା ଡିପୋଜିଟ କରିବେ, ପାଇଁ ମୁଁ ସେ ରଖିଦେବି।
No, Your Lordship, there has
ସେଇ
never
ଟାଇପର ଜିନିଷ ନା, ଆପଣ
there has never been such a long delay, Your Lordship.
an important post and you are utilizing the public money and not depositing in time. So, and
Ye-
this is not one occasion. This is continuously it is going on. 5 charges
Yes.
are there. So,
Your Lordship, the 5th charge is not regarding that. It is regarding another officer has misappropriated the money, and due to lack of supervision of the petitioner, the charges have been framed against the petitioner. Your Lordship, my humble contention is that, Your Lordship, the punishment order itself states that the government money has been misappropriated and it has been taken by the petitioner for his personal gain. Your Lordship, there is no pecuniary loss caused to the government money, Your Lordship.
That is not the consideration.
And neither the petitioner has gained anything. Every money has been accounted for, Your Lordship. There is a dereliction, no doubt, Your Lordship. There is a dereliction in his duty, and he has deposited it once 1 day later and once after few days, Your Lordship.
It amounts to misappropriation. It is not, even if whether you have deposited after some days or hours even. It amounts to kindly read the.
I bow down, Your Lordship. Even the Honorable Central Administrative Tribunal, Your Lordship, has stated that even if there is no pecuniary loss, Your Lordship, there is dereliction of duty. My humble submission is that for a dereliction of duty of this sort, especially when the petitioner has accounted for the delay, and
How many times? He's in the habit of doing this.
Your Lordship, it has been
Once in a blue moon it has happened. Yes, we can understand that. Yes, there could be some difficulty. But having taken the money without depositing it in the account of the bank, wherever, or in the, you should have opened an account and kept it in the bank itself.
That is the contention
What made
of
you
the
to
petitioner.
keep the money with you?
No, Your Lordship, the contention of the petitioner is that it was kept in the sealed iron trunk, Your Lordship. It has not been considered. My only contention is that such dereliction does not amount to a punishment, Your Lordship, such as removal from service, which is highly disproportionate.
no criminal proceeding has been initiated.
No, Your Lordship.
409, nothing.
No, Your Lordship.
So, what about those decisions which you said that you will face some decisions that this dismissal from service on these charges was not justified, even if this type of allegation is there?
Lordship, the decisions are that the interference The court can interfere when the punishment is shockingly disproportionate, Your Lordship.
How you say that it is disproportionate?
The only reason is, Your Lordship, because there is no loss of money or neither there is any gain to the petitioner, Your Lordship. He has accounted for everything. There is delay, no doubt, Your Lordship.
In each case, how many days after you deposited the money? There are how many charges are there? 5, na?
5, Your
So
Lordship.
you come to the charge sheet. These 5 charges are, that is at page articles 1
page 47. 47.
It starts from page 51, Lordship. 51.
Article 1. Yeah, Annexure 5.
16. No, Your Lordship. Annexure 1 is the charge sheet, Your Lordship. Page 16 has Article 1.
page 16.
Yes, Your Lordship.
1/6. Let us see. पढ़िले कौन लिखिଛି? Please read it out, madam.
That said Shri Dhaneswaran, while working in the aforesaid capacity during the period, has received Dundo BO.
You are reading Article 1.
Which one?
I oblige. Article 1, Your Lordship. Shri Dhaneshwar Soren, while working as SPM Bahalda SO in account with Rairangpur HO during the period from 15/4/2016 to 13/10/2016, on 14/7/2016 has shown cash remittance of rupees 50,000 to Rairangpur HO by this office daily account dated 14/7/2016. But physically, he did not remit the cash to Rairangpur HO on the same day. Rather, he made over the said cash to Rairangpur HO on 15/7/2016 in the evening. By the above act, Shri Soren has violated the Rule 8 of Postal Manual Volume. Article 2, Your Lordship. That's
what it says that have you seen that Rule 8? The allegation against you is that you have violated the Rule 8 of the Postal Manual Volume 6, Part 3, that was published in March 1985. Have you got a copy of it? And what that rule says? When you are challenging the order, you are supposed to go through that rule.
Yes, Your Lordship. Your Lordship, it was referred to before the Honorable Tribunal, Your Lordship.
And also you are to provide a copy to us to see that what it says. Rule 8 of that.
Your Lordship may grant me one more opportunity, Your Lordship.
Again, you see Article 2 रे से refer करछन the Rule 29 of the Postal Manual Volume so and so. Then the Article 3 रे Rule 29. Article 4 रे Rule 29. Article 5 रे Rule 29. So दीटा rule आपनको violation अच्छी बेले allegation आसी गोटे होची Rule 29 गोटे आउ गोटे होची Rule 8. So दीटा को rule आनंतु देखिवा कौन है से rule.
Yes, obliged, Your Lordship.
The learned counsel for the petitioner. You have filed some citations today.
Yes, Your Lordship.
Filed some citations which are taken on record. However, while placing the charge sheet, which contains 5 charges against the petitioner, it appears that it is mentioned therein that the petitioner has either violated Rule 8 or Rule 29 of the Postal Manual Volume PI, Part 3, published on March 1985. When counsel submits that the matter may be taken up next week so that he will produce the aforesaid rules, put up this matter in the week commencing from 25th November, that will be 2nd December 2024. Yes.
Much obliged, Your Lordship.
Mr. Presence of the land council, the party, and outreach.
Deepak, the good chat. The good chat.
Which I do. Yes.
Item 16.
My lords, I am appearing on behalf of Mr. S.S. Das. He is having some personal difficulties.
You are appealing for Mr. S.S. Das.
Yes, your lordship.
What do you want?
Lordship, I am praying for an adjournment. He is having some personal difficulties.
No. Adjournment till next week or a week
Till next week.
Next week.
Yes, your lord.
You have got power in this case.
Yes, your lordship.
What is your good name?
Trupti Ranjan Mahapatra.
Mr. T.R. Mahapatra Land Council submits that the matter may be taken up of this matter commencing from 2nd December 2020. Yes.
Our appearance may be noted, my lord.
Mr. Party and
BK party, man. BK party.
BK party, है ना? Central government council. Yes.
Item 17.
May I please, your lordship. Your Honor, the petitioners have prayed for grant of R&R benefit because they have lost all their homestead as well as agricultural lands in course of land acquisition process.
What happened to your representation under Annexure 3?
That representation has been forwarded under Annexure 4, my lord. Page 28.
किसी communication file नहीं?
Yes.
What communication you have?
Page 28, my lord.
Page
20 is forwarded.
This forwarded.
Yes, that is.
So any reply we
No, my lord, no. That has not. That is pending, still pending before the collector, my lord.
Representation filed under Annexure 3, it was forwarded to so and so, but no reply has been received. They say the certified copy production for your 3 months with disclosure for it. Yes, next.
Item 18.
The proprietor of this firm is a lady entrepreneur who has 20 years of experience in fabrication of iron. Now she evinced interest to expand her business and applied for land. Lords, your lordship may kindly turn. Annexure 3 is her project report, which was approved by DIC at page 32. The district level facilitation cell recommended proposal.
Where is your application for grant of lease?
I made application by each Alan, that is page 31, Annexure 4. That is the way we have to make an application for land before the ITCO.
So that was on 5/6/20.
5/6/20.
What happened thereafter?
Thereafter, on
Your
16/7/2020, yes, 16/7 it was approved, and my ITCO white page 37 granted me the land. Your lordship knows during that time the pandemic had destroyed the entire industry, and as a result I issued a letter that please give me installments at page 38 to deposit the amount.
No, the letter of the Chief General Manager is at Annexure 7. That is dated 19/7/21.
19/7. Yes, that is the approval letter.
Right.
That you will be granted land, pay this amount.
And some conditions have been there.
Correct.
So you have not fulfilled those conditions.
I have not fulfilled. I wrote a letter, next page, my lords, page 38, that please give me some time, make 6 installments by which I can make a deposit.
Any response you
received? No, I have not received, not a single response.
Annexure 9 also again another
letter I have given in 23. Yes, there is a laxity on my part that I did not follow up the matter. That is a laxity, I admit that. And that's the reason I have not filed any interim application.
I don't know whether that land is still there.
There or not, yes.
So, Mr.
ITCO, they have a special counsel. So
Mr. Manti is there, bro.
We suppose that is exactly.
There are panels of
Senior counsel Pradipta Manti is appearing.
Served a copy.
No, but they have panels, so notice has to go. There are 25 counsels.
Usually, Mr. Manti is
Mr. Mahanti, you give him a copy so that it can be listed tomorrow, so that it can be expedited. We can take instruction because if since Mr. Pradip Kumar Mahathir and a senior advocate used to appear for ITCO, did a copy of the writ petition be served on him during course of the day. Matter will be read tomorrow, indicating the name of the land and senior advocate in the court. I just give a copy and tell him that this is the order passed.
Yes.
Of this matter.
Since he is a senior counsel, and
Yes, in his office you can. Mr. Pranay Mahanti, you can take it. Or anybody in his office.
Objection. Can it be on Monday, my lords?
Yes, no problem. 2nd December 2020. So by tomorrow,
By tomorrow, कर देल बा.
copy is to be served.
Grateful.
December 2020. Name of Mr. Yes.
Item number 21.
Lord,
21.
here the challenge is
90%
order
power.
annexure 1, which starts from page 13. With regard to the issue of providing employment to the land house families. This is initially their lands were purchased by Tisco, now Tata Steel. Tata Steel, subsequently the whole company is taken over by Shiva Cement. The land was purchased by erstwhile Tata Steel. My lords, I'll just request my lords to see page 64. When this issue of employment came.
Sir, is there anything for Shiva Cement?
Beg pardon?
Is there any role of Shiva Cement here?
In fact,
if it is there, then I'll make it. I was the lawyer.
They are claiming employment under that.
In fact,
it has been taken over.
Shiva Cement has taken over Tata Steel.
Like Shiva Cement involves?
No. Shiva Cement has been taken over by Tata Steel.
Yeah.
I think it is not Tata Steel, it is SCC.
Shiva Cement or the management transfer same management or
I think MD is still there as advisor.
No,
I don't know.
Place 15, the Shiva Cement.
If it is there,
claiming under Shiva Cement claim. The Tata Steel has written.
This matter before some other bench in which one of us, Honorable Justice is not a party. Yes.
21, 23 and 31. These three.
23 Sabu Shiva Cement.
Shiva Cement.
21.
23.
23. Yes.
31. And 31.
Yes.
Item number 22.
May I please, Lord? The petition challenging the order passed by the Central Tribunal Court of Bench Qatar, passed in OA number 535 of 2019, dated 25/9/2024. Page 138, Lords. Page 138, Lords.
That is the improvement order.
Yes, sir.
Yes, what was your prayer before the land and tribunal?
This petitioner, duly selected PA, postal assistant, under RTP scheme, Lords. And thereafter continue regularized 1986, Lordship. They have paid their Lordship. Similarly, placed persons in different benches as well as implemented that order. That given that period is extended the benefit of financial benefit, that is PGOB and MSC periods. Lordship,
we just want to know that what was your prayer before the
page 27, Lordship.
27.
Page 27.
27, the prayer is not there. 27, it starts 10, 11, and 12. List of enclosure verification, maybe prior to that. Relief shortfall, that is in 26. So the prayer is to quash the order dated 19/3/2019.
Yes, sir.
And to what is that order? 19/3?
19/3/2019, they have rejected. Page your lordship. Page
That is annexure 1. Annexure 1.
Sir.
Tapare to direct the respondents to extend
Yes, sir.
similar benefit as extended to others in the matter of regularize their service from the date of their initial appointment
Yes.
rendered as RTP.
RTP.
What is the full form of RTP?
Reserve Train Pool.
Reserve Train
Pool.
For the purpose of granting final upgradation under
EPOP and
MSCP scheme.
Time bound of one promotion and that is MSCP is the modified AC.
So why it was torn down by the learning tribunal? What is the reason?
Reason, your lordship, paragraph 19, your lordship,
Page number 151.
Sir.
Yes, please please.
Equally, the US principle of our that a settled thing should not be unsettled after a long lapse of time.
Please use the mic. Please, yeah.
Equally, it is well settled principle of the law that a settled thing should not be unsettled after a long lapse of time. Further, it is well settled law that the persons who shall be affected in case of relief is granted to an against must be assigned as a party to the litigation. In the present case, the applicants are appointed as PA during the year 2000, that is 1986. That is regulation, Your Lordship. They woke up from the slumber by making repentance in 2018, that is after a lapse of more than 3 decades, paying inter alia for their regulation of their services from the date of their initial enrollment. The RTP for granting the financial upgradation under TBOP, MSCP on the analogy that the RTP employee who was not regularized approached the various tribunals wherein orders were passed to regularize them retrospectively, but no explanation of forthcoming for not being vigilant, if at all they had adequate an individual right to regularize from the date when they were inducted as RTP starting from the day they were appointed as PA in 1986. Therefore, allowing the benefit by condoning the delay would tantamount on settling a settlement matters after about 3 decades. Further direction of retrospective regulation at this stage would have much more adverse repercussion affected, and it may so lead to offsetting the promotional effects, etc. It cannot be affect the promotional avenues, Your Lordship, affecting the rights of the others who are not before this tribunal. Hence, taking into consideration the entire aspect of the matter, this tribunal is well convinced that this is a matter where no leniency can be shown to the applicants. On examination, we find that the facts and issues of the earlier wave 5394 of 2019 are same and similar to the present case, and therefore we see no justification such and such. This way, Your Lordship, also challenged before the Honorable Court and issued notice, Your Lordship.
Same order.
Yes. Same order. Notice was issued, Your Lordship. I have not removed from making the prayer for the promotion. Regularized for that period for financial benefit, Your Lordship. In view of that, they have extended the benefit, different angles and. See, 534. They have relied the 534. Dated 7/12/2023.
ସେମାନେ କଣ ସେଇ 30 ବର୍ଷ
ଆସିଥିଲେ ଆଜ୍ଞା ସେଇ ସମୟରେ ସାର୍ 1919 ଆସିଥିଲେ 534 2019 535 2019 good one ଢେଙ୍କାନାଳ division ଅଛି ଆଜ୍ଞା
the learned counsel, the petitioner, Prema Rendu Pal.
Premanandu Pal.
Premanandu Pal.
Premanandu Pal.
Premanandu.
Prema Rendu লেখাই
Prema Rendu. Premarendu
Premarendu has filed this writ petition challenging the order dated 19/3/2019 and 19/3/2019 passed by
the authority.
passed by who is the opposite party number?
Opposite party.
Superintendent of Post Office.
Post Office.
Opposite party number 3. So also order dated 25/9/2024 of the London Central Administrative Tribunal, Cuttack Bench, in OA number 260/00535 of 2019, in which the prayer made by the petitioner for regularization of his service was torn down, mainly on the ground of delayed approach to the tribunal. The London Council for the petitioner submitted that similarly situated persons have also challenged a similar order passed by the London Central Administrative Tribunal before this court in WPC number 10539 of 2024. And as per order dated 30/4/2024, notice has been issued to the opposite parties, and therefore the matter be tagged to WPC number 10539 of 2024. He files the copy of the order along with the impugned order in the said case, which are taken on record. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Counsel for the Union of India, Mr. Padi, along with
Mr. Kashyap, S.S. Kashyap.
Mr. Kashyap, Purana Dati Akontu.
Satya Sindhu Kashyap.
Land Central Government Council accept notice for opposite parties number 1, 2, and 3. So, no notice be issued to opposite party number 4. Put up this matter after 4 weeks, along with WPC number 10539 of 2024. So, counter affidavit, if any, be filed in the meantime. Next.
Item 24.
My lord, OGLS matter, my lord. My representation is pending before OP number 5, my lord.
Which is the representation?
My lord, Annexure 3 is my representation.
Annexure 3. All right, Annexure 3 is pending before Tahsildar Bhubaneswar.
My lord.
He is opposite party number
5, my lord.
5. Take a decision. Next.
Yes, sir.
Item 25.
May I please, my lord? The petitioner, there is a land lodger. He is seeking direction for.
Your representation is Annexure 7.
Yes, my lord.
Annexure 7 to be disposed of. Yes, next.
Item 26.
Item number 26. Lords, this is again in pursuant to the directions of the Honorable Apex Court. The same claims commission matters, my lord. Lords, here, although I have made a representation to the claims commission for against the action of MCL in not considering the order or the orders passed by the claims commission, in not dispersing my compensation as per the directions of the commission. My lords, the order, I'm not challenging the order, it starts at page 17.
No, now the claim commission is not functioning.
Now it is not functional, my lords.
You have to file a press representation if you want. You can before the appropriate authority. Who is that appropriate?
My lords, appropriate authority is ADM, OP number 5. But my only difficulty is that, my lords, all my claims were allowed with respect to multiple displacement, with other claims were allowed. Now MCL has come up.
He has to consider because
Yes, my lord. If that can be observed, my lords, I'll make a representation.
petition has been filed by the petitioner, Nandlal Shah, with a prayer for the following direction. While counsel for the petitioner submits that though for the claim commission, a miscuse was instituted at the instance of the petitioner for grant of compensation to him for acquisition of his land and house sold.
My lords, land and structure both. Land and structure.
But since the claim commission is now not functioning and the matter is sub judice before the Honorable Supreme Court, the petitioner may be permitted to file a press representation before the opposite party number 5, additional district magistrate, bracket RR Sundargarh, taking all the grounds, and the concerned authority may be asked to consider the representation in accordance with law. Current counsel for the state has no objection. Accordingly, it is disposed of. There will be 2 weeks he is to file the representation and it will be considered. Along with the copy of this order, he has to produce the copy of the reputation. Yes, and order to be communicated within 15 days of the taking the decision. Yes.
Grateful.
Item number 27.
So someone
May please. And I have a glance to page 30. Annex 4 is pending with the opposite party number 1.
Opposite party number 1.
Madam.
Kibbe date kibbe?
That was sent through registered post
So,
on 17th of 10, 2020.
16/10/2020. Representation under annexure 4 to be disposed of and order to be communicated within 15 days of the taking the decision. Yes.
Item number 28.
Same
opposite party, same.
29.
Union
29.
Sorry, madam. 30. Sorry.
All right. 30 is same.
Annexure is Annexure 6 pending with the OP number.
Annexure different ଅଛି.
Annexure 6.
30 ଟାରେ ହେଉଛି annexure 6.
My lord, 28. Your lordship may pardon me. On verifying, I found that my index is wrong. I am challenging annexure 8. In the body,
you have to file a fresh index or what? All right.
Lordship may keep it to next week.
We'll just mention it. There are, and counsel appearing for the petitioner submits that since the index filed with the recognition is not correct, he intends to file a corrected index and the matter may be taken up next week. This matter will be commencing from 2nd December 2024. Yes.
Oh, blessed.
Item 29.
Annexure 6 page in the sign.
Annexure 6 is the representative.
You're writing 5 and 6.
5 and
6.
6 is pending before whom?
Collector.
Opposite party number?
2.
2.
Madam. Collector.
Okay. 6 is pending before of the number 2. That is to be disposed of. Yes.
Item number 32.
One of the
lying under section 64 considered.
It is to be considered and if necessary it is to be referred, right? Or it has not been done. When you have filed this LA case 26/2023. All right. This petition under section 64(1) of the so and so is pending before this one. So opposite party number? Opposite party number 3. Decision will be taken.
No,
waiting.
4, my lord.
4. Collector of fire, no, this case is pending before opposite
Special,
party number 4, right? Opposite party number 4. And a decision regarding a reference of the matter to the court under section 18 of the LA Act for redetermination of the award under section 23 of the LA Act be taken within a period of 8 weeks from the date of production of the certified copy of the law. Yes.
Item number 33.
In this case, my application under section 28A has already been adjudicated, and the special land acquisition officer, and next up to page 22, requested the government to sanction the decretal dues. That is pending with the government. And in similar circumstance, you see page 25 and 26. In that case, that application was pending. So you are directed to adjudicate, and if he is entitled, then that shall be disbursed.
Now it has already been adjudicated.
Yes, adjudicated.
It is only to be payment to be made.
Yes, sanction and payment.
Annexure 3 টা দেখি কিনি তাহলে তাদের লিখবে যে it has already been, the amount has been adjudicated and matter has been referred to so and so, hello? Opposite party number 2. Yes. And the amount is sanctioned and stays for disbursement shall be taken. Okay.
Item 34.
Time by the time.
He has to take the decision within 3 months, that is the usual order. Yes, next.
Item 35.
And 34. No, 34.
Item 34.
May I please, Your
Yes, Mr. Mishra.
Sorry to interrupt, my lord. Item 30, the union is there. I could not follow.
30.
Railway is the party.
Mr. Samal.
27, Mr.
Representation.
That you want to incorporate whose name? Just tell me.
This by the way, Mr. Maharana is.
Item number 30 है Mr. Maharana को ना add कर दो apart from Mr. Maharana. Yes.
May I please, Your Lordship? Now, earlier, the petitioner had approached the Honorable Court challenging the notice issued in terms of the provisions of Surface Act and praying for a direction that they should settle, the bank should settle the loan account under OTA scheme. I wish to draw Your Lordship's kind attention to Annex 4 at page 40. The Honorable Court, taking note of the submission, was pleased to dispose of the requisition. Paragraph 2, Your Lordship, page 40, Your Lordship may kindly peruse. The Land Senior Counsel, Sri Samit Mishra, submits that since in the meantime, the opposite party number 1 has floated some schemes for one-time settlement of type of loan which facility the petitioner has availed of. The petitioner wants to withdraw this requisition so as to approach the opposite party number 1 with necessary application to avail the benefit under the floated scheme and the guidelines in force for consideration of one-time settlement of the loan account in proper perspective, and decision in accordance with law, taking a sympathetic view that the petitioner has not willfully defaulted in making the payment of loan dues, but it was on account of some unavoidable circumstances standing on the way. Accepting the submissions from Mr. Mishra, the Land Senior Counsel of the petitioner, we dispose of this requisition, granting the liberty as aforesaid. Pursuant to this, my lord, under Annex 5, page 42, I made a representation. My lord, Your Lordship will kindly see the last para. I said that in view of the above direction of the Honorable High Court of Orissa, I request your good self to provide me the details of the OTA scheme in vogue so as to enable for settlement of both the above mentioned loan account under OTA scheme. Now, my lord, Your Lordship, I have to point out one thing. Under the OTA scheme, they make a deposit of first ask for a deposit of 25%, then the balance amount is to be deposited. Without intimating as to which scheme is vogue and what is to be deposited, they directly asked me under Annex 6 at page 43, and I have to draw my lord's kind attention to page 44 and 45. In one account, they demanded 77,44,786, and the other one 38,59,562. These also I agreed. I will point out to your lordship, though the time given was, your lordship will kindly find, they make this demand on 9th July, page 43, and to payment to be made by 26th. Without, my lord, any 25% direction and anything like that. Straight away, they say that you pay this amount in total, without indicating as to how they have arrived at that amount also. Now, I requested under Annex 7 at page 46 that this 26/7 deadline is difficult, so grant me some further time. Now, my lord, instead of doing that, they have put the property to auction, fixing the price at 1 crore 34 lakhs. Now, I intimated them under Annex 9 at page 48, saying that the property is worth of 2 crores 50 lakhs. So, you are selling it at 1 crore 34 lakhs, which is very less. And that will also add to my loan account if at all, my lord, it is adjusted. Now, they responded to it under Annex 10 at page 49, your lordship, saying that you arrange a buyer. But this arranging a buyer, time was given was again 7 days, paragraph 2. And despite this position, with your lordship's kind permission, I am filing an affidavit today. It's a deed acquisition. My lord, I have arranged a buyer at 2 crores 15 lakhs. I'll just point out one more thing for your lordship's kind appreciation. Your lordship may kindly turn to page 54.
What happened to the auction sale notice?
Man, that has not yet been carried out. Some buyers are visiting the premises. Man, that is my instruction.
The date must have been fixed there.
My date was fixed, your lordship. That is at page.
What is the date?
On 29/10/24.
Right. But my lord, it has not been settled as on today, at least till yesterday. One more thing I'll just point out for your lordship's kind consideration. Page 54, your lordship may kindly see.
You take before the plan and DRP.
Only one thing may I just, if your lordship pardons me only for a moment, page 54 only. Yes. I got it valued through a registered valuer. Your lordship may kindly see.
Take all those grounds, Mr.
My lord, what I humbly beg to submit, your lordships have been pleased to hold that this kind of grossly low price fixation itself is a, my lord, abuse of process of the provisions of the Act.
Next case. Case item 35.
Will your lordship only, I will pray, my lord, will your lordship kindly protect me for a period of 7 days only?
You liberty, you approach next day. Tomorrow you can approach. Yes, next. Item number. Yes.
Section 14 application of the petitioner has been allowed since 2015, my lord. Thereafter, the possession could not be taken out, and in the year 2024, a letter has been issued by the bank, and which has been confirmed by the ADM by Annexure 6, my lord. That they have stated that the order passed was valid also. Thereafter, we deposited the amount by Annexure 7 before the SP Sundargarh, my lord. Thereafter, we are writing to the SP to give date for police protection and the collector to fix a date. But till that has not been done. As per the order back in the year 2015.
No.
Which order was kindly have plans to Annexure 3, my lord. Yes. 15.
That's all right, but EB recently ordered the
recent order, my lord. There is no recent order, my lord. No, that has been valid bully someone question. If there is no stay order, what is stay order? There is no stay order. But here the
ଆପଣ ଏଗୁଡାକ ଏତରେ ଲେଖିଦେଲେନି ଯଦି ଷ୍ଟେ ଅର୍ଡର ଅଛି ବୋଲି ତେଣୁ ଆପଣଙ୍କ ପାଖରେ କେହି ପ୍ରଡ୍ୟୁସ କରିନାହାନ୍ତି କୌଣସି ଷ୍ଟେ ଅର୍ଡର that presupposes that nobody has produced, at least the other side, the person who has upheld the loan and he is likely to be evicted, he has not produced any order, even though it was passed in 2015. And so that is why it is stated that we have already, this is the address to authorized officer writes to superintendent of police. That was on 16/5/24.
Yes, ma'am. So, thereafter, deposit has been made. They have taken the
deposit कथड़ा ताज़े लिखा ही ची मतलब. As we have deposited the required amount for deployment of police force. तापर अपन किसी response पाई ना दी.
नहीं, again, बर्तन सुधा देना. Only they have to consider it and take necessary step as per law. I have given the judgment, your lordship, where they cannot adjudicate the matter.
ଏଇଟା କଣଟା ତା ପରେ ଯୋଉଟା ଲାଗିଛି
ADM ଗୋଟେ କଣ ଦେଇଛନ୍ତି 15/2/2024 ରେ communication has been made to the authorized officer by the ADM.
Yes.
This is the latest letter. That's
Yes, madam. Because
28/5 ଟା କଣ?
28/5 ରେ ଆଜ୍ଞା ଆମେ ଲେଖିଲୁ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ପୋଲିସ କି ଆମେ ଏତିକି ଚାଲାଣ କରିସାରିଛୁ ଅଲରେଡି, ଆପଣ ଦିଅନ୍ତୁ ପୋଲିସ ପ୍ରୋଟେକ୍ସନ ଦିଅନ୍ତୁ।
All right, this petition has been filed by Punjab National Bank with a prayer for a direction to the opposite parties to take necessary steps as per surface law, take physical possession of the mortgage property, and for deputation of executive magistrate and police force by fixing date for taking physical possession of the secured asset as per the order dated 17/12/2015 passed by the collector and district magistrate Sundargarh bracket opposite party number 1. The land counsel for the petitioner submitted that on 16/5/2024, also on 28/5/2024, the petitioner submitted representation before the Superintendent of Police, Raurkela, wherein it is indicated that the amount which is required for deployment of police officials has already been deposited, and therefore the authority should provide police assistance for taking over the physical possession of the scheduled property as per the direction of the district magistrate Sundargarh, but no response has been received from the superintendent of police in that regard. The land counsel for the state has received the copy of the writ petition. Considering the limited nature of grievance, we dispose of the writ petition with a direction to the Superintendent of Police, Raurkela bracket opposite party number 3, to consider the representation of the petitioner filed annexure 8 series in accordance with law, taking into account that the order was passed by the district magistrate Sundargarh way back on 17/12/2015, and if there is no other impediment, then necessary police protection shall be provided to the petitioner for taking over the physical possession of the scheduled properties as per the direction of the Land District Magistrate Sundargarh within a period of 4 weeks from the date of production of the certified copy of this order. Writ petition is disclosed. Yes.
Only one. The opposite party number 2 may be cooperated. The subletter has to deputy a person, magistrate. Only that much. Opposite party number 2 sub-collector has to deputy a magistrate also.
So, in that regard, if the assistance of the opposite party number 2 is sought for, the same shall also be provided. Yes, next.
Item number 36.
Please, Lord. This is a case of preventive detention loss. Plus the opinion number 2, invoking the power under section 3 of the Prevention of Illicit Traffics and Narcotic Drugs and Psychotropic Substances Act 1988, has detained the present petitioner by order under Annexure 1. That you will also get at Annexure at page 15. I have got 3 points in this case. Here was regarding the subject.
What happened thereafter?
No, subsequently that has been confirmed by the advisory board. That is at Annexure 4 loss. 127 page. Of course, that order of the advisory board has not been supplied to me, and but the order has been given to me by the central government. There it is reflected that and where the matter of Nilakanta Pradhan, son of Vishnu Pradhan, was placed before the PIT NDPS State Advisory Board, Odisha, which is of the opinion that sufficient cause is made out for the detention of the detainee Nilakanta Pradhan, and subsequently accordingly it has been confirmed. But here my humble submission of the lordship is, this is also a violation of Article 14 of the Constitution of India.
What is this Annexure 5?
Annexure 5 is that has been referred to the advisory board, that is on 29/8/2024. That should have been referred prior to 27/9/2024. Because it's 5 weeks from the date of detention. So date of detention being 23rd July 2024, within 5 weeks it should have referred to the advisory board.
4 weeks, 6 days. That is 4 weeks, 6 days.
Then that is that itself violates.
And within 5 weeks, section 9, section 9.
And
so what happened if it has been referred to the advisory board, and that ultimately on 29/8/2024?
Then advisory board confirmed, as it is clear from Annexure 4, page 127.
What is the confirmation letter?
Annexure 4.
Annexure 4.
Yes, Annexure 4.
Is second subparagraph, and whereas the matter of Nilakanta Pradhan, son of Vishnu Pradhan, was placed before Swanso State Advisory Board, which is of the opinion that sufficient cause is made out for detention of the detainee Nilakanta Pradhan. Central government has considered the opinion of the Swanso. Now, therefore, in exercise on power of Swanso, the central government hereby confirms the aforesaid detention order dated 23/7/2024, and further directs that under section 11 of the said act, Nilakanta be detained for a period of 1 year from the date of detention. Okay, so let us see the provision of the relevant provision.
Section 3. PIT NDPS Act.
Yes,
Plus, I want to draw your lordship's attention to section 3 of the Prevention of Illicit Traffics in Narcotic Drugs and Psychotropic Substances Act. There is power to make orders detaining certain persons. Have also got it?
Yes.
The central government or state government.
Power.
The central government or a state government, here plus the central government, or any officer of the central government not below the rank of a joint secretary to that government, specially empowered for the purposes of this section by that government, or any officer of state government not below the rank of a secretary to that government, specially empowered for the purpose of this subsection by that government, may clause here is important, may if satisfied. This is subjective satisfaction. If satisfied with respect to any person, including a foreigner, that with a view to preventing him from engaging in illicit traffic in narcotic drugs and psychotropic substances, it is necessary so to do, make an order directing that such person be detained. A person can be detained without trial clause.
Yes.
And here, my humble lordship, from the dossier itself, the ground.
Proceed.
Yes. When any order of detention is made by a state government or by an officer empowered by it, state government is not required in this case. Shall within 10 days forward to the central government is not required. Section 2. For the purposes of clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not less than 5 days, and in exceptional circumstances, and for agents to be recorded in writing, not later than 15 days from the date of detention. Here, in this case, same day, the grounds of detention has been supplied to the detainee. So this is also not applicable. My point is on the subsection 1. That is, if satisfied. That is regarding subjective satisfaction. That is 1. Now, I am taking your lordship to section 9. That is advisory boards. For the purposes of subclause A of clause 4 and subclause C of clause 7 of Article 22 of the Constitution of India, because Article 22 of the Constitution of India that relates to preventive detention. The central government and each state government shall, whenever necessary, constitute one or more advisory boards, each of which shall consist of a chairman and 2 other persons possessing the qualifications specified in clause A of clause 4 of Article 22 of the Constitution. Save as otherwise provided in section 10, the appropriate government shall, within 5 weeks from the date of detention of a person under a detention order, make a reference in respect thereof to the advisory board constituted under clause A to enable the advisory board to make the report under subclause A of clause 4 of Article 22 of the Constitution of India. So reference should have been made within 5 weeks. Here my point is, plus it has not been made within 5 weeks. Then plus clause C, the advisory board to which a reference is made under clause B shall, after considering the reference and the materials placed before it, and after calling for such further information as it may deem necessary from the appropriate government or from any person called for the purpose through the appropriate government or from the person concerned, and if in any particular case it considers it essential so to do, or if the person concerned desires to be heard in person, after hearing him in person, prepare its report specifying in a separate paragraph thereof its opinion as to whether or not there is sufficient cause for the detention of the person concerned, and submit the same within 11 weeks from the date of detention of the person concerned. Plus here there is a dark, because whether it has been passed within 11 weeks or not, that I don't know. Okay. Then because I am coming to
once notice is issued, they will file their counter.
Yes. That is the process. Usual process. That's the usual process.
Admit the Grand Council for the state wish to accept notice of the
Union of India.
Union of India for OP number 1, 2, and
1, 2, 3.
1, 2, 3. 3 টা মধ্যে তাঙ্কর তো?
Yes.
Union of India.
So opposite for OP number 1, 2, 3. Union of India, Mr. Paril accepts notice so far as 4 and 5. ଏଗୁଡାଙ୍କ ପାଇଁ ପକ୍ଷ କରିଛନ୍ତି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସର୍ଫ କଣ କରିବ? ଆଚ୍ଛା ହଉ 4 and 5 land council for the state accepts notice and extra copies of the writ petition be served on the land council for the Union of India, so also the land council for the state. Matter will listed କେବେ ରଖିବା ତାକୁ 4 ତାରିଖ ଏଗୁଡାକ ଶୀଘ୍ର ଶୁଣାଣି ହବା ଦରକାର ମିଷ୍ଟର ପାରି ଫାଷ୍ଟ ଭାଙ୍ଗି ଯାଇଛି ଆଚ୍ଛା ହଁ ସେ କେମିତି କଣ So this matter will be commencing from 16th of December 2024. Humble prefer second week, I mean 9th. 9th yes. 9th he परिवने already in custody since about more than 3.5. But they have to file their counter affidavit. The main yes, by 9th if necessary is not that is the problem from car problem
Who hanged them?
16 for the हम देखियो से आसो आज ना उड़े काउ कोई भी सेंट्रल गवर्नमेंट काउंसिल का ना का
Kashyap, Mr. S.S. Kashyap.
Kashyap को ना एंट्री कर देवे apart from the so matter to be listed the for them on 17 it will come in the supplementary list. Hello? Yeah.
Item number 37.
Yes, 37, Mr. Mahanti.
May please, your lordship.
Personal to the order dated from liquidates for issuance of notice not yet received.
No, my lord, I have supplied copy to Mr. Dayanidhi Mahanti. He has said that he will appear in this case, but he has not filed his wakalat.
He has stated before this court that he will appear.
No, ma'am. On
Then
that day, I have appeared for the bank, and also I have.
Who asked you to give a copy to for a private party to a council? Under what authority he accepted it? He has not made in statement that he has instruction to appear for OP number 3. Why did you serve a copy?
My lord, he has. I may be permitted to phrase a request, my lord.
Land counsel for the period the office note indicate that the liquidates for issuance of notice to opposite party number 3 has not been filed. Requisites shall be filed by tomorrow. Failing with the writ petition shall stand dismissed without further reference to the bench. Yes.
My name may be reflected. I will file the wakalat now by tomorrow.
The Mr. Biswal and counsel submits that he will file his vinama for the opposite party number 1 and 2 by tomorrow. If the vinama is filed, the same shall be taken on record and the name of Mr. Biswal shall be reflected in the cause list henceforth. Yes.
My lord, my lord.
If the requisites are filed, office to proceed as per the order dated so and so, and the matter be placed, give another date. Yes, next.
My lord, the interim order.
Interim order is 9.
Yes, my lord, it is in the IA.
Interim order. Who said that there is an interim order? We direct that the operation of the order. No, we are vacating this order. Well, what is the prayer in this? DRAT.
It is DRAT order against.
No, we are vacating the order. if so and so and the order is not filed, the petition shall stand dismissed and the interim order dated so and so shall stand vacated. Yes, next.
Item 38.
Was item 38. Your Lordship may see Your Lordship's last order dated 14/11/24, where the entire matter has been encapsulated. The writ petition has been filed by the petitioner to set aside the order dated 7/1/2017, passed in WL Miss Case number 23 of 2013, passed by the additional Tahsildar Bhubaneswar in rejecting the prayer of the petitioner to record the land in his name in the ROR. It is the contention of that the original lessee of the land in question, situated in village Dalua, was one Sridhar Majhi, whose wife sold the land to one Rashmi Rai with due permission by executing registered sale deed. And the petitioner, who is a Navy personnel and captain in Indian Merchant Navy, purchased the land from the said Rashmi Rai. Initially, when the additional magistrate Khurda and Lease revision case number 107 of 98 by order dated 31/3/98 in exercise of the powers under section 7A of the Orissa Government Land Settlement Act 62 cancelled the lease granted in favor of the original lessee, the present petitioner challenged the order of the ADM before this court in WBC 14429 of 2006 and by order dated 14/11/2006. A division bench of this court has been pleased to quash the order passed by the learned additional district magistrate Khurda dated 31/3/98 and please revision case number 107 of 98. It was further submitted that the learned order that the said order passed by this court has not been challenged by the state and that is how the same has attended finally. However, in the impugned order, the additional Tahsildar, taking into account the resumption of the land to government khata which was done earlier, has set aside the which
And
was
set aside by this court.
court in the aforesaid writ application has refused the prayer made by the petitioner to record his name in the ROR, which is not proper and justified. Your Lordships then wanted the original
Lease
lease,
WL
given to that Majhi man that they are supposed to produce before your Lordship.
Land Council pointed out that from the order sheet of the order of the Tahsildar Bhubaneswar,
Yes.
dated 10/6/2014, in WL case number 1, which indicates that the DA lease has been submitted so attached to the case record. Time to produce case record of WL is case number 1. So, yes.
That is that. We have not obtained a prey for some time. The originally lease of 771/72 is also required. What was the court terms and conditions stipulated in that?
That there अछि se case record re hi अछि se list ta apno said that is the what he
in
pointed
WL
out.
case only that has been produced.
Yes,
that order indicates 10/6/2014 order passed in that WL case indicates that the lease deed is there. So once you produce the case record, everything will be there.
Sometimes may be allowed.
Has been remanded by the apex court to be decided expedition.
Land Council for the କିଛି communication କରିଥିଲେ order ପରେ
ନା ଏ ପରେ କିଛି record does not
order ଟା pass ହେଲା 14/11 ରେ ଚୁପଚାପ ବସିଗଲେ କେମିତି? ଆଜି ଏସରେ 26 ତାରିଖ ହେଲାଣି ଆପଣ ସେଇଦିନ ଅର୍ଡର ଅପଲୋଡ ହଉଛି ଅର୍ଡର ଟା ପାସ୍ ହେଲା ଆପଣଙ୍କର ସାମ୍ନାରେ କୁହାହେଲା ଏଇ ରେକର୍ଡ ଟା ପ୍ରଡ୍ୟୁସ କରିବା ପାଇଁ the Land Council for the state takes some further time to produce the case records of WL Miss Case number 23 of 2013. List this matter. Next week supplementary answer produce from 4th of you are available, Mr. Karan, on 4th of December 2024. Yes.
Item 39.
Yes.
on matter, Your Lordship, were attached with the court magistrate
Yes.
office. Your Lordship, last order, Your Lordship, we've been protected by the interim order, but no payment is being paid. Your Lordships had directed them. The issue here is that the registry also is being represented by the same lawyer, and the government is actually not wanting to cooperate, is also represented by the same lawyer. That's a little
Payment of
dicey
salary
proceedings. Should have
and
gone
area salary to the opposite party. So what is your instruction, Mr.? Interim order is there, of course, since
You are
long
not
it
getting
is there.
anything.
That's why last time Your Lordship said that something positively has to come. And they had assured it, but there was a
No,
difference then.
there is a circular for that, and they could have continued until a regular order is passed by the government. What is their difficulty?
They are working.
Hmm,
They are working. They are not paying.
No, but there is a standing order that they'll be getting from the contingency, and the government will pay the money on the course of time. It has happened on many occasions. I don't know how. Quickly, you can have it.
Yes.
Ask RG and get it.
7-8 as per the 7-8 order I place.
अरे काम କରୁଛନ୍ତି ନା ପଇସା ପତ୍ର ଦେବେନି କଣ?
They have the government is having a very funny logic. It's as if the head of an office is missing, as if every other staff will stop working. And that's their logic.
Of this matter, on 4th of December 2024, Land Council for the State shall obtain instruction in the matter regarding payment of salary and pending area salaries of the petitioner. Yes. It has been family rights now. Land senior advocate and interim order to continue till next 2 years.
Item 40.
Get on that.
For the petitioner, this retribution I have prayed for issuance of a direction to the bank for handing over the physical possession of the property as well as for registering the sale certificate.
You are the auction purchaser.
My lords.
You have deposited the entire due.
My lords, since 2019, and sale certificate has also been issued since 2019.
So, any step has been taken under 14.
It was
Then we are pursuing last reason and for need to character settlement to explain why you are not taken the possession. Now the law is that they have to take the possession and hand over to you. No, that's all right. Yeah, that is order dated 31/8/2024. In person, please trace that order, sir. If you have got that copy of that order. Please बाहर को दो ना दी वाक कमरे. 31/8/2024 order.
So he is there.
This matter is in pursuance to the order of dated 8/8/2024. The Learned Counsel for the State has produced the written instruction dated 22/8/2024, received from the DIG cum Deputy Commissioner of Police Cuttack, wherein it is mentioned that after receipt of the communication from the Collector and District Magistrate Cuttack by letter dated 29/12/2021, necessary police arrangement has been made for taking possession of the secured assets on 25/8/2022 under the intimation to the authorized bank by memo number 3912 DIB dated 23/8/2022
And on 25/8/2022, the authorized officer of the Regional Stress Asset Recovery Branch, Bank of Baroda, Bhubaneswar, has been to spot along with police personnel, but the matter could not be materialized for some technical issue regarding the situation of the scheduled property, and thereafter no further correspondence has been made by the concerned bank for taking over the possession of the secured asset. The letter dated 22/8/2024 be taken on record.
Yes, so it is now you are to. This is the response they have given that they are not able to locate that which particular which is that particular scheduled property. So you are to specify it and submit a detail of that property so that they had already taken steps. It's not that they were sitting silently. And you have also been communicated that letter is dated 22/8/2024 and
We have not been communicated anything like that. But can you see the annexed D of my account? That looks like that.
no no ଆପଣ ଏଇ ଯୋଉ ଲେଟରଟା କୁଆଡେ ଗଲା ସେ ଲେଟର
That has not come.
ପ୍ଲିଜ ପ୍ଲିଜ ସେ 22/8/2000 ଏଟା କିଏ ଦେଲାଣି ପ୍ରଡ୍ୟୁସ କଲା
This has been filed by the Learned Council of the State.
ହଁ
22/8/2024
ହଁ
was filed by the Learned Council for the State.
and that is taken on record
Yes.
My lord, my lord.
ଲେଟରଟା କାଇଁ
ସେଟା ହେଲା 22/8/24
22 ଏଠି ଦେଇଛନ୍ତି କି ଦେଖିଲ
Record.
ରେକର୍ଡ
In Annexure D, where is the schedule of property? Schedule of property kind.
filing. The letter is dated 22/8/24.
23/8.
23.
That is on
No,
the
no,
police
22,
commission.
23.
But
At 22.
the police commissioner Katak report is there in the.
No.
It
They are
was-
available.
It was filed on 27/8/2024 before this honorable court.
ଓହୋ
27/8.
ତ ଲେଟର ଏଟା ଠିକ ଇଏ ଡେଟ୍ ଟା ଭୁଲ ଲେଖା ହେଇଯାଇଛି
The two dates have been mentioned, my lords.
No, we refer to 22/8.
Yes, so this is 22/8 as well as 23/8 has also been mentioned in the same letter.
ଦିଟା
Again, the that mentioned question.
These are 23 na.
22.
23.
ଆଦେଶ କଣ ଲେଖା ହେଇଛି
It has been filed with
Ito copy ଅଛି here.
IAC Bidamasi will remain present and make necessary so and so if you deny it ତାଙ୍କର ଇଏରେ
This is their annexure. then. It Bank of Baroda.
Bank of Baroda.
Annexure D.
Specific है that is खाता number 475 by 114 and plot number 105 ସେଦିନ ଯୋଉଟା ଏଇ ସବମିଶନ ଟା ଯୋଉ କଲେ in the order dated 31/8/24 in persons of the order dated so and so the Learned Council for the state has produced written instruction dated 22/8/2024 ସେଟା କାଇଁ 22/8/2024 ର written instruction
That is based by C.
no
Out.
no.
By set.
Yes, what instruction you produced before us on 22/8/2024? This is from DIG cum Deputy Commissioner of Police Cuttack, wherein it is mentioned that after receipt of the communication from the collector, District Magistrate Cuttack by letter number 29/12 so and so.
So that is another letter.
Police arrangement has been made for taking possession of the secured asset on 25/8.
That letter available on 38 there, it will, Binanais police will remain
Under
present.
intimation, so and so, authorized bank by letter dated so and so. Have been to the spot along, but the matter could not be materialized for some technical issue regarding the situation of the scheduled property, and thereafter no further correspondence has been made by the concerned bank. The letter dated specifically ଲେଖା ହଉଛି ଗୋଟେ କଣ 22/8/2024 ଗୋଟେ ଲେଟର ଆପଣ ସେଦିନ ପ୍ରଡ୍ୟୁସ କରେ ସେଟା କୁଆଡେ ଗଲା? ସେ ଅଛି କପି ଅଛି ଆପଣଙ୍କ ପାଖରେ?
ଏଟା 22 ରେ ଦସ୍ତଖତ 23 ରେ ଇସ୍ୟୁ।
ହଁ ଦିଅନ୍ତୁ।
Is a technical, see technical issue also there last para.
এটা 22 এটা 2024 ର latest ଯୋଉଟା ପ୍ରଡ୍ୟୁସ କରିଥିଲେ ଏଟା କୋଉଠି ମିସପ୍ଲେସ୍ ହେଇଛି। ଏଇଥିରେ ଲେଖା ହେଇଛି କ୍ଲିୟରଲି ଯେ with reference to the letter on the subject cited above, it is to submit that the Honorable Court has been pleased to direct the undersigned that as to why the police assistant has not been provided to the secured creditor in taking possession of the secured asset as per the order dated so and so of the collector and district magistrate in bank miscase number so and so. Further, the Honorable Court has directed to submit the compliance report in this regard. It is submitted that the collector and district magistrate by memo number so and so had passed the order to the effect that all assistance shall be provided to the secured creditor in taking the possession of the secured assets of Ahmad Khan and Sufia Bibi. Both are at Tulasipur, Gorakhabar. Accordingly, necessary police protection has been made for taking possession of the secured asset on 25/8/2022 under intimation to the authorized bank so and so that on 25/8/2022 the authorized officer of the regional so and so had been to the spot along with the police personnel, but the matter could not be materialized for some technical issue regarding the situation of the civil property. Thereafter, no further correspondence has been made by the concerned bank for taking over the source. এই চিঠিটা আপনি পাইনাନ୍ତି? এই order এইটা সেদিন প্রডিউস করতেলে অর্ডারে লেখা হলা, but you have not kept it on the file. বুঝিপারল না? Huh? M.K. Raut has taken the decision. ଯାହା ପୁରା କଣ୍ଟେଣ୍ଟ ସବୁ ଲେଖା ହେଇଛି, ଚିଠିଟା କିନ୍ତୁ ମିଶି ବୁଝିପାରୁଛନ୍ତି? Keep a copy on the record, and you provide a copy also. I would copy Karan, Mr. Karan to give.
We have gone to the site and found that that road has been enclosed by some other person. For that reason, we have requested them to remove it. We have not taken any step to remove it.
Who will remove it?
Police will remove it.
Encroachment.
Police has done, unless that removal is there, we cannot go to the.
Unless there is a direction from the competent authority, police cannot encroach.
That is a property charged for the bank, and you have not seen that it is enclosed. It was in your custody.
No, my lord, now in the due course of time it has been enclosed.
Whatever. How could you say that at what point of time it is under encroachment? How could you say?
Whatever you are making the submission, nothing is there on record.
Yes.
Because this communication has been made, and that has been made to the, of course, Advocate General Office. But you said that it has not been, a copy has not been forwarded to you. But okay. So this later indicates that a press communication correspondence has to be made that to how to carry out that order because he's suffering. The man who is the successful auction purchaser and has deposited the entire money. It may be when you deposited the money.
2019.
No.
So you had also not seen the schedule of property before.
Seen for going for auction.
So it was
clear because the sale deed was kept as mortgage before the bank. In that also there is a clear sketch map wherein road has been prescribed and physically also it was there. But the neighbor he has made a temporary shade over that passage
only.
only. But the police expressed their inability to remove because there is no direction.
So the bank
has to take initiation. Bank has to take because his property he has to
taken the money and you are sitting silently.
You may minor after giving the issuance of certificate, minor can see we have gone to the collector and we have got the order. Then
No, it's all right. Now the problem which has arisen because somebody has enclosed the access road maybe that and constructed something. So for that you have to file some petition so that that obstacle or that hindrance can be removed and you will get the physical possession of the lands.
In this regard, we have approached to the commissioner of the
whatever you want to do, you do.
Nothing
but
is on
you are
record.
not doing anything. That is the reason why the DCP has stated that from thereafter you are not making any correspondence because you have received your money. That man is suffering.
The police assistance is only for a law and order situation. It is not for removal of encroachment. So a specific order direction has to be there.
Right. That is to be that sort of appropriate action is to be taken. Some application is to be filed, mentioning all the details and what is the problem, how why it could not be, and this would be the letters of this DCP etc. would be a factor which would assist the bank in passing an order in your favor that the hindrance is caused by X and Y. That is why they are unable to carry out the order.
And now the statute speaks that they have to take over the position, not assistant question is there.
बाबा अप्रोच रोड रे जने ब्लॉक कर रही ता पई किछि ऑर्डर हेनी सी टेक ओवर पोजीशन कोन शून्य रे जाई नै जिवे ना कोन ताकू जो बाट देहिछि ता बाट परा बंद कर रखिछि थर्ड लोक से थर्ड लोक एगेंस्ट रे जदी किछि नाही ऑर्डर ता घरटा केमि भांगी देबे ता पार्टीटा भांगी देबे तेणु यू हैव टू फाइल सी दैट हाउ दिस person get the position.
Section 14 speaks of that. Kindly read.
No. Take permission to take over possession. That doesn't mean that I mean
take over possession and hand over to the tenants.
The scheduled property upare the collector can give any direction. When the scheduled property is being enclosed by other person in other way.
No. They find it difficulty to approach that spot because there has already been
not being properly identified accordingly.
One is not identified. Second time, as the submission made that the auction purchaser that somebody has constructed some shade as
and they just probably
on the approach.
Spot map. ସମୟରେ ଗଲ ଘର ଅଛି ବନ୍ଦ ସେଟା ଫିଜିକାଲ ଫଟୋ ଦେଇ ଦେଇଥାନ୍ତା ନା
Yes.
Some 14, 9 onwards, sub 9 or some 14 is 34. That is the same.
এইটা নয় না ফিজিক্যাল
Made thereunder had been complied with, provided further that on receipt of the affidavit from the authorized official, the district master or the chief metropolitan magistrate or the case may be, shall after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured asset within a period of 30 days from the date of application. Then after 60 days they can with reason can extend. And then after provided further, next paragraph, provided also that the requirement of filing affidavit is stated in the parcel not applied to the proceeding regarding the district magistrate of the chief metropolitan magistrate as the case may be on the date. The district magistrate or the chief metropolitan magistrate may authorize any other subordinate to him to take possession of such assets and documents relating thereto and forward such assets and documents to the secured creditor. They will take out the possession and hand over. No, the problem that has arisen is one letter it says that the scheduled property could not be identified. And in another letter, he is making a mention or submitting that somebody has already constructed something temporarily, said for which it is not possible to approach the scheduled land. So something must come on record that, and you have to take steps, you have to make communication. Now you have got this letter today, this 22/8/2024. To see that person, otherwise you will pass the bank to give compensation apart from giving, you give compensation to this person because he has already suffered for 5 years. You have to compensate and the interest amount you have to pay on that. ଆପଣ ସି କାହିଁ ସଫର କରିବାକୁ ଲେଖି ଦିଅନ୍ତୁ the copy of the letter dated 22/8/2024 of the DCP Cuttack has been served on the Land Council, Mr. G.D. Kara, who is appearing for opposite party number 2. He submits that no such letter has been earlier received from the DCP by the bank, and therefore some time may be granted to obtain instruction in the matter and what steps can be taken further so that the petitioner Muhammad Qais can get the possession of the land in question. Put up this matter on 4th of December 2024. This you keep in record. All right, put it on 10th of December 2020. Very good. Play. Take it off. Oh, no, so Lordship, partnership item 43. Tomorrow, I have to find the result of the then 43. 43, the London Council.
43.
WPC number 17618.
Sir.
London Council for the petitioner submits that he has received the counter affidavit filed by the opposite party and intends to file rejoinder affidavit, and 2 weeks time may be granted. Let this matter 2 weeks forward. Yes.
Supplemental list, item number 1.
Matter. By this I is the younger brother of the appellant. The marriage is scheduled to be held on 4th of December.
No, but is the how many appellants are there?
One.
Why have you filed 2 interim bail applications? One is
This is CRLA.
558 first hearing.
58, no? So there are two appellants.
No, two IAs are there.
Two
IA
IAs.
number 3671 of 23. Another is 2963 of 24. Which one? 23. Acha.
Not pressed.
IA number 671 of 23. This is an application for interim bail. Land and Council for the appellant submits that this interim application has become infructuous in view of the submission. What about this second one? 2963 of 24?
This one is I'm submitting that.
Yeah.
Yes, where the brother of the appellant, his marriage is scheduled to be held on 4th of December.
2963.
Yes. I have filed the Xerox copy, the original, but it is
ସାନ ଭାଇର ବାହାଘର କାଇଁ ଇଏ କାଇଁ କାର୍ଡ କାଇଁ
ସେ payroll ରେ ଯାଉଛି ପୁରା. How many times yes? On many occasions?
କେବେ ବାହାଘର କେବେ
4th of December.
କୋଉଠିକାର ଲୋକ ଇଏ
ଆଇଏ କପି ଦେଇନୁ.
There are two persons face trial. What happened to the other one?
Acquitted by you.
Acquitted. So he has gone on interim bail at any point of time.
For law on many occasions as it is ever. Three months for marriage. Either. That has to be done.
We are allowing this application subject to verification by the London Trial Court through the IAC that yes, this marriage of the younger brother is.
Let the copy maybe sir because of the
Copy.
You give him a copy for official purpose that is to be kept. IA number 296 of 24. This is an application for interim bail on the ground that the younger brother of the appellant is getting married, and today the Land Council for the appellant has filed the marriage invitation card with a memo which is taken on record. The Land Council for the state submits that he has not obtained instruction in interim application. Considering the submission made by the Land Council for the respective party, the government's taken in the interim application and the documents filed in court today, we are inclined to release the petitioner on interim bail for a period of 2 weeks from the date of release, subject to verification by the London Trial Court through the IAC of Shahdev Kunta Police Station relating to the government's taken regarding the marriage of the younger brother of the petitioner. Out of this matter, in the week commencing from such and such date, the Land Council for the appellant shall file the service certificate. Yes. 10 days कर दिया. Yeah. Next.
Item number 2.
କେତେ ହେଲା ପିରିୟଡ କୋଉଟା ଖାଇଛି କଣ ଏମିତି ଦେଇଛନ୍ତି
0000
4345
କୋଉଠି
ABC actual sentence period undergone as per the jail manual ABC
ABC ମିଶିଲେ କୋଉଠି ହଉଛି
4345
ଆଚ୍ଛା 4345 କେତେ ହଉଛି ମାନେ କରିଛନ୍ତି 365 ରେ
11 ବର୍ଷ something
11 ବର୍ଷ ହେଇଯାଉଛି
11 ବର୍ଷ 10 ମାସ 14 ଦିନ
ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି ନା ନାଇଁ ଫାର୍ଷ୍ଟ ଟାଇମ୍ what is the allegation against you
Allegations are
as per the
judgment
judgment particular
Article 2012.
come to the paragraph number 2 page 2 of the judgment
Article 2012. Article 415 consider various on a deposition of various. Reported deposition of various. Report in writing at the calculation on the same day Article 415 Rajesh Mohammed Vera forcibly entered into their house with a crowbar in order to cause the murder of his father. Assaulted his father brutally with the crowbar while causing his murder. This further stated in the FIR that accused on the same day further assaulted on Dr. Sahoo with the lease. Double murder. Double murder.
Double murder.
Oh. And Chandini Sahoo. The villagers with the spade and thereafter left that place. On receiving such report of the incident.
No, how many persons have died?
2%.
What about Chandini Sahoo?
Chandini Sahoo is 307.
Oh, acha. कारण कौन
Submitting blackmail.
No, he was suspecting that the deceased persons are practicing witchcraft or what?
For that he was
Eyewitnesses are there.
No.
How many eyewitnesses? PW 3, 6, 11, 16, 17, 18, 23. And doctor?
Doctor, 2% died that, but doctor
19.
The doctor who conducted
PM examination of both.
Daitari Sahoo.
Daitari has. PM report has been marked. No, but PM report has been marked. On admission is वो ଆଉ ସେ ଯୋଉ ଆରଟା ଯୋଉ 307 वाला
24.
and 27 both.
ଦିଟା କଣ ବେଲ୍ ଫାଇଲ୍ ହେଇଛି ନାଇଁ ନାଇଁ in the cause list it is mentioned that IN number 74 of 23 is for bail and 125 by 24 is also for bail. Good.
74 টা
23.
এটা not press করবো 74 of 23 টা not press করবো তারপরে 125 of 24 লিখুন the land counsel for the petitioner submits that the petitioner is in judicial custody for more than 11 years. And the paperwork has not been prepared, and therefore there is no chance of early hearing the case. And the petitioner is a local man, therefore the bail application may be favorably considered. It ଆପଣ ଆଜି produce କରିଛନ୍ତି ତ? Learned counsel for the state has produced the custody certificate from Superintendent Special Jail Raulkela dated 23/11/2014, which also indicates that the custody period of the petitioner as submitted by the learned counsel for the petitioner is correct. The learned counsel for the state, however, submits that it is a case of double murder of judgment of Charan of Behera and Doitari Sahu, and also for attempting to commit murder of Chandini Sahu. Chandini Sahu examining PW, that is PW 20. He further submits that the PW 16 PW 16. He further submits that PW 3, 6, 11, 12, 16, 17, 18, and 23 are the eyewitnesses to the occurrence. And PW 9 is the doctor who conducted PM examination. PW 19 is the doctor who conducted PM examination over the dead body of deceased Doitari Sahu, and the post-mortem report of the deceased Charan of Behera has been marked on admission. He further submits that PW 24 and 27 are the two doctors who have examined Chandini Sahu, Chandini Sahu, bracketed PW 16, 16. And therefore bail should not be granted, considering the submission made by the learned counsel for the respective parties, the nature and gravity of the accusation, the evidence adduced by the eyewitnesses, the post-mortem report findings, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention since more than 11 years, and that there is no chance of early hearing as paper book has not been prepared. We are inclined to release the petitioner on interim bail for a period of 3 months. But usual order. Date fixed up further, he has to practice to surrender certificate. Yes.
Item number 3.
Time land council for the states are also obtained prosperity certificate. Yeah.
Item number 4.
कितने वर्ष 15 years. Yes. And what is the judgment? Here, one appellant. One. Okay, so please come to paragraph number 2.
The prosecution case has been read that on 25/1/2009, the complainant and his family members came to Bambra railway station at about 3:30 p.m. to catch the DMU train to go to Bagdi. Subsequently, at 4:45 p.m., after the DMU train halted in platform number 1, the complainant and his family members are attempting to board the said train. The accused suddenly appeared in the scene, dragged the deceased and stabbed on the left side purchased by a knife. When the complainant tried to consult the accused, he attempted to attack him with that knife. By that time, the accused had already stabbed another person on his belly on the said flat. Then the general public captured the accused and manhandled him. Thereafter, the deceased and the injured PW20 were sent to Bambra Hospital for the victims succumbed to the injuries on the way. Then the complainant lodged the written report about the said occurrence as the GRP Darshudra by deputy said for criminal law. During course of
So that means it's a case also of double murder.
no.
One is dead, one was seriously injured.
और जो कोई victim मरीगला भी कौन कोई
And it is that victim
that
dead.
victim है.
अच्छा.
But another person who was there to came into rescue.
So what is the name of the deceased?
Pooja Naik.
Lady ना?
आगे.
Injured है. कितने वर्ष 11
11 years. 11 years.
Oh. अच्छा. How injured किए?
20. Joy.
Stabbed on the left side of her chest by a knife.
Maharana.
Rana.
He is PW20.
20.
And who is the doctor? PM doctor and
PW 19.
PW9.
19.
19. How you injured को?
18.
तो गोटे इंजर्ड ना दीटा इंजर्ड
जने इंजर्ड जने डेथ
नहीं आ गोटे सेठी लेखला बाय दैट टाइम द एक्यूज्ड हैड ऑलरेडी स्टेप्ड अनदर पर्सन ऑन हिज बेली
दैट सेज राना 20 की 20 से तो रेस्क्यू पे हेला ही ताको भी
ना सेटा तो ऊपर लिखिले when the complainant tried to catch hold of the accused he attempted to attack him with that knife by that time the accused had already stabbed
that means
two injured
is not the only injured
no
there is another
two injured
father of the that is PW20
20 the injured
PW13 father of the deceased the informant stated that he also
PW13
I am the informant, yes. He is also injured.
So, the weapon of offense is knife.
Para 6 रे describe is pura. Para 6 of the judgment describe is it. Doctor
19 तो
direct
PW19 पर PM doctor देख लो.
That knife bullet has not been produced in the court, although it has been executed.
PW19 I conducted one stab as a good single stab on the left side chest.
But say that death is.
How ye how you the time injured माने?
How they use the present apparent melody, you also certainly injury the people manually. সেটা তো he examined but he is appellant.
No, no.
Other is yours.
PW20
अच्छा যশোকেতন বর্মা লিখলি না এটা বর্মা হচ্ছে অ্যাকিউজড ও যশোকেতন রাণা রাইট দ্যাট ইজ PW20 incised wound on the abdomen. So that means the eyewitnesses must be PW13, PW20. Oh, just a minute. 5, 6, 13, 14. Out? 20.
21.
20 पर अकेले झोसकेतन राणा
injured eyewitness
अच्छा so 21 they are the eyewitnesses. कोडिया लोग कोई अच्छा so the address is correct, Mr.
I will have to verify that.
Address verification कर दियो तो you also arrange for local sureties if it at all be so. The learned counsel for the petitioner submitted that the custody certificate indicates that the petitioner is in judicial custody for more than 15 years. However, the learned counsel for the state submits that since the petitioner is a man from state of Bihar, as per the cause title, he may be given some time to verify whether the address furnished in the cause title of the appeal memo is a JCR in the impugn judgment is correct or not. The matter be listed in the week commencing from 9th of December 2024. The Superintendent of Police of Jharsuguda shall make necessary correspondence with the Superintendent of Police of Aurangabad, the state of Bihar, for verification of the address in question. Free copy of the order be handed over to the Land Council for the state for compliance. Yes.
Item 5.
You have received the deposition copies. You have also received.
No. Okay.
No. There was a direction as per the previous order that you have to take the deposition in the pen drive.
And there I can take a seat from this also.
You can
Here
go through it. So, what is the conviction?
Life.
302 case. So, how many years you are in custody? 13/5, 2014. In trial court, you are not on bail. Sure. Please come to the paragraph 2 of the judgment. Read it. Let us see that what is the prosecution case. Yes, name of the deceased is Vanita Das.
Wife of murder of wife.
Yes, indeed, with that accused of the matter, see, the doctor of the Indian Medical Level, they were staying with the informant who looked after her. By that time, the accused was working as a driver at some of the mines. The doctor was born out of the order, the deceased and the accused. He was aged about 2 years and 6 months. There was frequent quarrel between the deceased and the accused for about 3 months, as he had kept his relationship with other only. On 11/5/2014, at about 4 p.m., there was a quarrel between them and the accused was assaulted the deceased. On 12/5/2014, at about 8 p.m., the informant had seen the accused pass through side of her house. She also had cry of children and found the deceased was making booming sound at the gong gong, and there was pot bleeding injury on her throat. The deceased also disclosed that the accused had pot her throat, and after saying so, she died. So, for the informant lodged a petition on which Hayapani PS case number 25 12/5/2014 was registered and investigation was done. After completion of investigation, charge sheet was submitted against the present accused for the offence under section 302 IPC. The case record was received after being committed by the Court of Revision Judgeship. Accordingly, charge was framed for offence under section 302 IPC and the accused is trial there.
So PW 15 is the doctor,
Yes.
and he has noticed that main injury is on the neck, and the cause of death was also due to deep cut throat injury, right? And there may not be any eyewitness to the
No,
occurrence.
eyewitness there.
Okay.
PW5 minor son.
Yes,
The very important.
PW5 minor son.
They're very important.
Dying declaration.
Dying declaration, sir.
With the evidence. Who is
The husband matter. The Learning Trial Court held that though there is the dying declaration, but it was not, there was no material.
belief discarded.
The 5 statement is minor, with the son who was seeing the occurrence.
PW5
seeing the occurrence from the inside. The son-in-law. Appellant is the son-in-law.
नहीं PW ये जो ये साक्षी आरो appellant रो कौन हो?
Nice.
अच्छा.
Nephew.
Nephew.
The son accused is the son-in.
Accused is addressed to me by uncle.
Uncle.
But he is the husband of the deceased.
Witness, though a child witness was put some general questions regarding food and food, to which he gave rational and natural answers. So he examined. I know the accused who is addressed by me, uncle, but he is the husband of my deceased mother, Vanita. I have seen the accused killing my mother during evening hours in the body of the accused killing my mother by means of a knife and cut her throat. By remaining inside my house, I saw the entire exercise by window as the spot was lighted by lights due to
cutting of neck.
Mother who was groaning under Congo sound. So soon after cutting the neck of my mother, the accused fled away from the barrister. I was examined by the police in cross-examination. It is not a fact that I heard about the occurrence. The decline. The witness, being a child case, asserts in the open court that he saw the accused dragging his mother to bury and cut her throat, which the witness had seen during the course of occurrence after returning from execution. It is not a fact that at the instance of video for my grandmother, I have been trained or tutored to speak in this manner. It is not a fact. At the instance of the public prosecutor, I am speaking falsehood. It is not a fact that without seeing anything, I am speaking false at the instance of my grandmother.
The immediate occurrence is the PW3. While he was fled away from through the body, the PW3 has Vinay.
Hmm.
I know the deceased, Bonita, and the accused present in the dock. Bonita is my childhood friend. On 11/5, 2014, at 4 p.m., while I was going to bring water from the tube, saw the accused proceeding with daughter with a bike and swimming. And when I asked him to bring sweet from the market, the accused stated that he had assaulted his own wife, Bonita, who is my friend, and showed his bloodstained hand to me, and also reiterated that he will kill his own wife, so saying he went out. 2 days thereafter, I had uh, been
This
house
is
of the
this is extrajudicial confession.
yes.
This is believed or disbelieved?
Cross examination. I am questioning that cross examination. That the prosecution, so also by the defense. When the accused was passing by the Sahib, he stopped the motorbike and had some chit chat with me for some time. Also stated that this is the prosecution by prosecution. There was a quarrel between himself and his wife Bonita, and for that reason, the accused brought his grandchild on the control of the Bonita and also stated before me to finish Bonita by talking her name. It is a fact that earlier the accused stated before me to kill his own wife Bonita many times. On the date of visit of the house of the accused, I came to know that the accused got the neck of his house and killed her. I was examined by the police in this case. But in the question of defense, he has stated that I don't have any information about the parents of Bonita. Bonita married the accused for the second time. Bonita was blessed with 3 sons out of her first marriage. And the one is deceased, married to the appellant for the second time. I don't have any idea as to why the first marriage of Bonita never lasted. I cannot say if the mother of Bonita was pressuring the first husband of Bonita to stay in their house as a domestic son-in-law. It is not a fact that I am suppressing the truth. Knowing well about the family of Bonita, I don't anything about the first wife of one and two. Interview 1 and 2. So who this question has relied upon. They have declined in the
Declared counsel for the petitioner submitted the petition within judicial custody since 14/5/2014 and associated remaining in custody for more than 10 years. Further submits that the petitioner happen to be the husband of the deceased, Vanita Das, and the uh, main evidence is that of the minor son of the petitioner and the deceased who has been examined as PW5 and stated to have seen the petitioner assaulting the deceased by means of a knife on the neck. We further submit that though the prosecution adduced time declaration evidence against the petitioner, but the Lennon trial court has discarded the same. However, the Lennon trial court has relied upon the extrajudicial confession evidence adduced by PW3. And since there is no chance of early disposal of the early hearing of the appeal in the near future, as paper which has not been prepared, the petitioner bail application may be favorably considered stopped. Land counsel for the state opposed the prayer for bail and placed the evidence of PW5 was stated as to how the petitioner, by means of a knife, cut the throat of the deceased. He also placed the evidence of PW15, the doctor who conducted post-mortem examination and noticed uh, injury on the neck and opined that the cause of death was due to caught throat injury resulting in neurogenic shock and hemorrhage. Land Council further placed the evidence of PW3 was stated about the dying declaration made by the appellant. Considering the submission made by the Land Council for the respective parties, nature of evidence available on record, particularly that of PW5 and the doctor bracketed PW15, were not inclining to release the petitioner on bail on merit, but taking into account a period of detention for more than 10.5 years. And since there is no chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months. Fix the date for filing the surrender certificate. Yes, ma'am.
Item 6.
Yes, madam. The document custody since 2015.
Prisoners petition so on so filed going nama. States some like they are not having the deposition copies. So deposition का पहले
Yeah.
अरे अपन 9 मिनट कौन पेन
नहीं I can go through this, but in the problem is that file is not having with me because I'm not received. That's why I prepare some. I can take help of the desktop of deposition.
वाकम पर अच्छी तो फाइल किसी ने अपन बेल मूव करियो ले देख परिवे. What is the offense?
Offense matter 302 arrive for live matter.
Judgment of what?
Custody since 2015.
Just a minute. এটা
SC/ST
কোন যাইছিল নোটিস না ও acquitted. So 302 রে লাইফ ହେଇଛି. Just a minute. 6. So what is your date of custody, you say?
4/1/2015.
4/1/2015.
This is Narayan Porda.
Narayan Porda.
Narayan Porda.
PARDA. अच्छा.
PW13. Doctor matter PM Doctor matter PW13.
PW13.
Format matter PW1.
No, what about the eyewitness?
Eyewitness, there is no eyewitness. Entire case is based
No eyewitness.
Circumstantial evidence.
Achha. What are the circumstances?
Circumstances.
So please come to that paragraph number 2 of the judgment. Let us see that. What is the fact of the case?
On 2015, night at about 9 p.m., the accused went to the house of the deceased Narayan Pratap, situated at village Radhanagar under Viswedias limit. The accused told the deceased to accompany him to visit the house of his elder brother, Kulchan Pindan, situated at village Rupuri site, with a view to take chicken meat and spend the night there. Thereafter, the accused and the deceased went towards the Rupuri site by holding one torchlight each. On 3/1/2015 morning at about 7 a.m., the informant Ramesh Chandra Bhatta received information that the dead body of the deceased Narayan Bhatta with injury on different parts of his body was lying below the embankment of dry tank situated by the side of the road at the outskirts of village Sangamani. After getting such information, the informant rose to the spot immediately and found the matter to be true.
Okay. What are the circumstances? Has it been
last scene theory that has been already mentioned in Improved Judgment paragraph 7 manner.
One is last scene. Who has stated?
1, PW1, 2, 3, 4, 5, 8 and 9.
1, 2, 3, 4, 5, 8 and 9. So last scene, then what else?
Extrajudicial confession before police.
Extrajudicial before police?
Madam.
No independent witness has stated.
No.
अच्छा छोड़ो तापरे आओ कौन
appellant instance
आओ कार
that is an embankment of
oh that was lying as such.
Lying.
27 not there. So mainly is that last scene and So PM doctor is PW 13.
12 individuals.
Very powerful.
Use all stem injuries.
Star wounds.
Sabu staff. Staff cutting, staff cutting.
Right arm, back. Why you assaulted the deceased? What is the reason behind it?
Reason manner as per the there is a part present in improved judgment matter. There is a motive and intention as paragraph 10 that actually shows in improved judgment matter. There are two parts that is comes out from the mouth of the P.W. 5 and P.W. 8. P.W. 5 stated that prior to the date of incident, the accused buried the dead body of his mother in their land, for which a quarrel ensued between the accused and her son Nara, which deceased, and for which the accused bore grudge and threatened the deceased to kill. That is the statement that has been given by P.W. 5. And similar P.W. 8 stated that who is the sister-in-law of the deceased has also stated in para 2 or evidence that 3 years prior to the date of occurrence, the deceased Narayan had a quarrel with the accused as the accused was releasing his cattle into their paddy fields every time.
Immediate motive କିଛି ଅଛି ନା ନାଇଁ?
Immediate motive no man.
ଏ ପୁରୁଣା ଯୋଉ ଘଟଣା ଗୁଡା
ଆଉ ସେଇ ଯୋଉ 1 2 3 4 5 8 9 କହିଛନ୍ତି ସେମ୍ ଥିଙ୍ଗ କହିଛନ୍ତି
ଆମେ ଯେ ଗଲୁ ଦେଖିଲୁ ସେ ଯାଉଥିଲା ଦେଖିବାର କେତେ ଦିନ ପରେ ମିଳିଲା ଡେଡ୍ ବଡି?
ଡେଡ୍ ବଡିଟା ସକାଳେ ଇନଫର୍ମେସନ
ନାଇଁ ଏମାନେ ଦେଖିଲେ କେତେବେଳେ ଆଉ ଡେଡ୍ ବଡି କେତେବେଳେ
ଦେଖିଲେ
ମିଳିଲା?
ଆଜ୍ଞା ସକାଳେ 7ଟା ବେଳକୁ ଏମାନେ ଦେଖିଲେ ଖବର ପାଇଲେ ଯେ କି ଆମେ ଏଠି ଗୋଟେ ଡେଡ୍ ବଡି ପଡିଛି ବୋଲି ସେଇଥିରୁ ସେ ପାଇଲେ.
He was seen in the company of the accused.
ଆରେ ବୁଝିପାରୁନାହାନ୍ତି କେତେବେଳେ ଟାଇମ୍ 3/1/15 ରେ ଆପଣଙ୍କର FIR ହେଇଛି ଆଉ ଘଟଣା ସିଏ ଦେଖଉଛନ୍ତି FIR ରେ ଯେ 2/1/2015 at about 9 PM ଦେଖଉଛନ୍ତି. ତାମାନେ ସେମାନେ କେତେବେଳେ ଦେଖିଲେ ଏବଂ ତାଙ୍କୁ
ସେ 9 PM ରେ ଯାଇଥିଲେ ବୋଲି ସେମାନେ ଲାଷ୍ଟ ଟାଇମ ଦେଖିଥିଲେ.
ଆଚ୍ଛା ତାପରେ ଡେଡ୍ ବଡି
ଖବର ପାଇଲେ ଡେଡ୍
ବଡି ଟା ତମେ ସକାଳେ 3 ତାରିଖ ଦିନ ମିଳିଲା.
Time gap is long, time gap is present.
That weapon was also recovered at your instance, or it was lying on
That is embankment of water tank.
embankment. ଆପଣଙ୍କର ହେଲା 9 ବର୍ଷ 10 ମାସ ହେଲା.
10 ମାସ 21. Supreme Court judgment is also there. Motive cannot be proved.
At the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submit that the petitioner is in judicial custody since 4/1/2015. Date ठीक ଅଛି ତ?
4/1/2015.
ଦେଖିଛନ୍ତି ତ?
ଅଛି ମେରା ଜଜମେଣ୍ଟ ରେ.
ଆଚ୍ଛା ହଁ 4/1/2015 and there are no eyewitnesses to the occurrence. The case is based on circumstantial evidence and PW's 1 2 3 4 5 and 8 and 9 are the eyewitnesses to the last scene of the appellant in the company of the deceased. And though it is stated that they were last seen on 2/1/2015 at about 9 PM, but the dead body was recovered on 3/1/2015 in the early morning. Learned counsel submits that there is no clinching motive on the part of the appellant to commit the murder, and therefore there are good chances of success in the appeal. And paper book has not been prepared, and therefore the bail application may be favorably considered. Learned counsel for the state submits that apart from the evidence relating to the last scene, it appears that the doctor bracket PW 13 who conducted post-mortem examination has noticed as many as 11 stab wounds on the body of the hot oblique inside oblique stab wound on the different parts of the body of the deceased, and he has opined the cause of death was on account of injury to the vital organ like long liver. Uh, Considering the submission made by the London Council for the respective parties, the nature of evidence available on record, the post-mortem report finding, while not inclining to release the petitioner on bail on merit, were taking into account the period of detention in judicial custody and absence of any chance of early hearing. We are inclined to release the petitioner on bail for 3 months and file the surrender certificate. Yes, next.
Item 7.
Then you know the petitioner of the interim bail, and yes, he has filed the surrender certificate.
All right.
Offense under section 302 and 307 of IPC.
It's all right. We are taking it on record. There is no further interim application.
Yes,
The current counsel for the petitioner, appellant, filed the surrender certificate, which is taken on record.
2813 of 24.
Yes,
2813 of 24 IAS.
nothing that has not come. When you filed the IE,
No, they will
you have
file
filed an further interim application for bail. What is the number?
My lord,
Time.
2813 of 24 IAS.
And have you given a copy?
Yes, Lord.
No copy. There is no copy. The London Council for the appellant submits that he has filed another application, interim application for bail. Right, IA number 2813 of 2020. London Council for the state submits that he has not received the copy of the interim application. Let a copy of the interim application be served on the London Council for the state. The London Council for the state shall obtain instructions regarding the conduct of the petitioner during the interim bail. Conduct has been received. You have already received. Acha, so pass on. London Council for the state has produced the written instruction received from by SDO Nandapur. SDPO Nandapur. Suffered mentally disruption, agony, and female peacefully.
Female.
Lady,
Julasa Huntan. He may live peacefully without affecting the society from which the convict will be released. There is a feeble chance of recurrence of crime and function. In favor of the life convict, and there is no chance of committing the crime. There is no danger to the life of the opponent. कहाँ को ये मर्डर करथिला? Husband. So you interim bill दियायला
ଆଗରୁ ବୋଧେ ଯାଇଛନ୍ତି।
Order dated 23/4 or 23/7. Please have been raised. Order dated jail custody ଅଛି 15/4/2011 ସବୁଗୁଡାକ ଦେଖୁଛି custody। କଣ ପାଇଁ ସ୍ୱାମୀ କି ମାରିଲା? ଶାଶୁ ଶ୍ୱଶୁର ଶୋଇଥିଲେ ଆଜି ହାଣି ମାନେ କିଛି
apparent cause କଣ?
କିଛି ଅଛି ଯେ ତା ସ୍ୱାମୀ କାହିଁ ମାଇଲା ଟାଙ୍ଗିଆରେ ମାରିଛି ପୁରା ଟାଙ୍ଗିଆରେ। ହଁ ରିପୋର୍ଟ ଆଣିବେ ସେଇ ଖଣ୍ଡିଏ ନେଇ ଆସିଛନ୍ତି ଲେଟିର ନାହିଁ ଅଭିଯୋଗ
ट्रायल बेले से बोलते बेल नथिला
नहीं
नहीं
देखा ही वेरीफाई कर लेता है जो 15/4/2017 पोस्ट रहती है आर द लैंड काउंसिल for the petition पर कंटिन्यू कर रहे हैं the land council for the state जो practice है service of property council अब वो property दे देता हूँ official purpose में दे the land council for the state has produced the report dated 26/11/2024 of the SDPO Nandapur which indicates as a main जगह छोटा देखिए सब लिखे हुआ है ना the same is taken on record considering the submission made by the land council for the respective party the fact that the petitioner is a lady and he has not misutilized the liberty and taking into account the report submitted by the SDPO and the principle laid down in the case of Leti alias Zayadev Rai, then so on so, we are inclined to release the petitioner on bail allowed.
Item 8.
May I please, your lords? Lords, pursuant to your lords, section 23(7), my lord, the petitioner appellant was released on interim bail and surrendered on 29/10, my lord.
Surrender certificate
Yes,
filed?
lords. Yes, my lord.
So,
And
have
on
you filed any other application?
yes, lords, that is 2981 of 2024, flag A.
So, any report has been received?
Yes, my lord.
What is the report?
Lord, the last portion it is ascertained that
नहीं दे दियो लोगों ने report है दियो तो report देखो ना एटा केते वर्ष रहिला पर जाइछला
Lords, after 8 years, 7 months, my lord. The custody is 9/12/2015. On 23/7, it was around, it was 8 years, 7 months. Your lordship has been pleased to grant interim bail.
Was interim bail for 3 months once surrender equally. This did not create any violation. No allegation has been made during the ମାନେ ଆପଣ ପାଖାପାଖି 8 years କେତେ ରହିଛି
8 years, 7 months on the date of first release of interim bail by your lordship. Your lordship has been on 23/7 has been referred this. Your lordship has been pleased to refer this on earlier order.
23/7/2024 ରେ जो
Lordship.
interim bail ଦିଆଯାଇଥିଲା ତା ଦେହରେ
Yes, lordship. And also custody set.
Eyewitnesses 1, 2, 7 and 9.
Yes, lordship.
Evidence Dr. La PW 23.
ଆମେ 23 से 10 ଅକ୍ଟୋବରରେ ଜଏନ୍ କର।
हाँ, letting state from RD11 council for the petition and council for the state. As per order dated 23/7/2024, after availing the interim bail period, the petitioner has surrendered. And home council submits that since there is no chance of early bail in near future, and the petitioner has not flouted the terms and conditions of the interim bail, bail application may be favorably considered. Learned counsel for the state has produced the report from IAC Borchana police station. Borogoda police station, which indicates that the petitioner has not created any violation and there is no allegation against him during his interim bail period. The report is taken on record. Considering the submission made by the land counsel for the respective parties, the period of detention and judicial custody, the conduct of the petitioner during the interim bail period, and further the report of the IAC Borogoda police station, and also keeping in view the principle laid down in the case of Letty versus Swan. So we are inclined to release the petitioner on bail allowed. Grateful.
Item 9.
দুই শূন্য ছ ন পাঁচ কি so you took time to file objection to the interim application. You filed?
No, objection filed.
How? File କଲେନି ନା ଫାଇଲ କରିବେ ନାହିଁ ଯାହାହେଲେ ଗୋଟେ କୁହନ୍ତୁ
next week file
of course it is a life imprisonment will condone the delay, but we want to know from you because an opportunity has already been granted to you since the delay is 2069. So
next week
you will file or not?
Next week.
Next week. All right, learn counsel for the state 6 time till next week to file the objection to the interim application for condonation of delay with this matter next week. Yes. Ready? ଆପଣଙ୍କର କେତେ ନମ୍ବର ଆଇଟମ କେତେ ନମ୍ବରଟା
ମ୍ୟାଡାମ ବିଶ୍ୱାଳ ଆପଣଙ୍କର କୋଉ ମ୍ୟାଟର ଥିଲା କି ଆଜି ନାହିଁ ତ
Item 19, my lord. Criminal appeal, my lord. Act 3 of 2015, my lord. I am ready, my lord. Your lordship was directed to appear after this matter, my lord. Yesterday, I am ready. I am on this email.
When you come to the court to argue the matter?
Tomorrow.
Where are you?
Puri.
My lord, I am in Puri VC, my lord.
Hearing matter order କୋଉଠି ପୁଣି disturbance ହବ ଏଠି
My lord, tomorrow, my lord.
tomorrow.
My lord, objection, lord. Item 19.
Yes.
Objection, lord.
Yun. Please. କିଏ କରିବ କିଏ? So, Mr. Pradhan, you have to argue this matter.
My lord. Just now I received the paper book.
अरे यही तो अपन अंडरस्टैंडिंग होची जे आपण माने गोटे केस हम
Appellant convicted under section 302.
माइक टा बंदी थी So it's a case under 302.
302
The mic टा बाहर दो
And 201.
201.
201 of IPC and sentence him to undergo arrest for life and pay of a fine of
Come
rupees
to the first
50,000.
information report.
Yes, let's see.
Then you
Page
go
number.
to. Let
Page
us
number
know the what is
18.
the prosecution case.
Page number 18.
Page number 18.
18, let's see. Sri Gautama Nayak.
Here, one. हाँ कौन
Sri Gautama Nayak ବୟସ
PW କେତେ
PW 12. PW 12 informant.
PW 12
12. ଗୌତମ ନାୟକ ପିତା ପଦ ନାୟକ ମଧୁପୁର ପୋଷ୍ଟ କଣ୍ଟେଇ କୁଳିଆ ଥାନା ହଣ୍ଡପା ଜିଲ୍ଲା ଅନୁଗୁଳ ଆଜି ତା 6/12/2015 ରିଖରେ ଏହି ରିପୋର୍ଟ ଦେଉଅଛି ଯେ ଗତ ତା 5/12/2015 ସମୟ ପ୍ରାୟ ରାତି 2ଟା ବେଳେ ମୋତେ ମୋର ଭିଣେଇ ଶ୍ରୀ ମାର୍କଣ୍ଡ ନାୟକ ଫୋନ କରି
Markonda Naik means appellant.
ମାର୍କଣ୍ଡ ନାୟକ accused
Yes.
ଫୋନ କରି ଜଣାଇଲା ଯେ ତୋର ନାନୀ କାଲି ଦିନ 11ଟାରୁ ଘରୁ କୁଆଡେ ପଳାଇ ଯାଇଛି।
Nani means the
ନାନୀ
deceased.
means the deceased.
कौन पुराना टा कौन
ହୀରା ନାୟକ
अच्छा हीरा नायक
ପଳାଇ ଯାଇଛି। ପୂର୍ବରୁ ମୋର ନାନୀ ଓ ଭିଣେଇ ପରସ୍ପର କଳି କଜିଆ ହୋଇ ମାଡ଼ପିଟି ମଧ୍ୟ ହୁଅନ୍ତି। ମୋର ନାନୀ ଆମ୍ଭ ଘରକୁ ପଳାଇ ଆସେ ଓ ଆମେ ନେଇ ତାଙ୍କ ଘରେ ଛାଡୁ। କିନ୍ତୁ କାଲି ମୋର ନାନୀ ଆମ ଘରକୁ ଆସିନଥିବାରୁ ଆମ୍ଭ ମନରେ ସନ୍ଦେହ ଜାତ ହେଲା। ତେଣୁ ଆମ୍ଭେ ତାଙ୍କ ଘରକୁ ସକାଳେ ଯାଇ ପହଞ୍ଚିଲୁ। ଖବର ବୁଝିବାରେ ମୋର ଭିଣେଇ ମୋର ନାନୀକୁ ତାଙ୍କ ଗାଁ ନିକଟରେ ଥିବା ବାହୁରି ଖୋଲ ଜଙ୍ଗଲ ଭିତରେ ପଥରରେ ଛେଚି ଜୀବନରେ ମାରି ଦେଇଛି ଓ ଲାଶକୁ ସେଠାରେ ରଖି ପଥର ମଡାଇ ଦେଇଛି। ମୋର ଭିଣେଇ ପଚାରିବାରେ ସେ ମାନିଲା ଯେ ତାର ସ୍ତ୍ରୀକୁ ଜଙ୍ଗଲ ଭିତରେ ମାରି ଦେଇ ପଥର ଘୋଡାଇ ଘରକୁ ପଳାଇ ଆସିଛି। ମୁଁ ମୋର ଭିଣେଇକୁ ସାଙ୍ଗରେ ଧରି ଜଙ୍ଗଲ ଭିତରେ ଦେଖିଲୁ ଯେ ଗୋଟିଏ ନାଳ ଭିତରେ ମୋର ନାନୀର ମୃତ ଶରୀର ଉପରେ 3-4ଟି ବଡ ବଡ ପଥର ଲଦା ହୋଇଛି। ସେ ପଥର କୁଆଡେ ଦେଖିଲୁ ଯେ ସେ ପଥରକୁ ଆଡ଼େଇ ଦେଖିଲୁ ଯେ ମୋର ନାନୀର ମୁଣ୍ଡରେ ଖଣ୍ଡିଆ ହୋଇ ନାକରୁ ରକ୍ତ ବାହାରୁଛି ଓ ସେ ମରି ପଡ଼ିଛି। ମୋର ଭିଣେଇ ମାର୍କଣ୍ଡ ନାୟକ ମୋର ନାନୀର ମୁଣ୍ଡକୁ ପଥରରେ ଛେଚି ଜୀବନରେ ମାରିଦେଇ PW12.
Is there any eyewitness to the
There is
occurrence?
no eye.
Okay, just a minute. No eyewitness. So the
Only
learned trial court has mentioned in the judgment what are the circumstantial evidence appearing on record against the appellant, or he has not done that. कौन circumstance अच्छी कुछ लिखी कि कौन सी
there is
जगह
only extrajudicial
extrajudicial confession is the only. Just a minute.
extrajudicial
Just a
confession is
minute.
not believable.
सीखे रूंदू extrajudicial confession कहाँ पकड़े?
Confession was
Evidence
before?
Which witness was stated?
The police officer or already other co-villagers.
मैंने
The
ये साक्षी की है जी की कोई ची extrajudicial confession who is that witness?
Say witness PW12 the informant nije जाइची से जाइची तागे कोई
PW12 is one witness. Any other
PW12
witness?
PW1 PW9 the mother of the
They have all stated that the accused confessed his guilt.
confessed before
Them.
them. That is no proof. They
No. Did the accused confess before these witnesses whom you are naming that he killed the deceased?
Yes, he stated that.
Alright.
But
That's all.
So that is
Rest,
one. So extrajudicial confession is one
appreciation.
item. What else are there? ଆଉ ତା ଛଡା ଛାଡି ଦିଅନ୍ତୁ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଛଡା ଆଉ କଣ ଅଛି ଏଭିଡେନ୍ସ ଆକ୍ୟୁଜ ନାଁରେ ଆପେଲାଣ୍ଟ ନାଁରେ? Any leading to discovery, any other material?
Discovery of weapon of offense ଅଛି?
weapon of offense
କଣ ଅଛି ସେଟା? Bloodstained stone.
the weapon of
ବାବା
offense.
ଆଗେ ମ୍ୟାଟେରିଆଲ ଗୁଡାକ ଟିକେ କୁହନ୍ତୁ ଏଇଆ ଅଛି ଆପଣ ଆର୍ଗୁମେଣ୍ଟ ଷ୍ଟାର୍ଟ କରିଦଉଛନ୍ତି ଆମକୁ କହିବା ଦରକାର ଯେ ଏଇଆ ଅଛି ତାପରେ ଆପଣ କହିବେ ଯେ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ଏଇଆ ୱିଟନେସ୍ ବଟ୍ ସେ ୱିଟନେସ୍ ଟା ଏଇ କାରଣ ପାଇଁ ବିଲିଭେବୁଲ ନୁହେଁ ଆମେ ଆପଣଙ୍କୁ ବର୍ତ୍ତମାନ ପଚାରୁଛୁ ଯେ କଣ ସର୍କମଷ୍ଟାନ୍ସ
extrajudicial confession and the circumstantial evidence.
Yes, that is the only circumstance.
Last seen theory by PW3.
PW3 is
ତାହେଲେ
କହୁନାହାନ୍ତି so last scene that is PW3. Then leading to discovery of weapon ଅଛି
ଅଛି
ସେ ଏତେ ଜିନିଷ ଅଛି
the
କହୁନା
same PW3.
Okay. So you start the extrajudicial confession you want to first of all. Okay, you press it. By the way, who is that doctor who conducted PM examination?
PW13.
PW13 is the PM doctor. Why don't you come to PW13 first? Let us see. Then we'll go to it.
Number 51.
Yes.
On 6/12/2015, I was working as a medical officer of PSC New Andapa. On said date, about 3 p.m. on police requisition, I conducted postmortem examination on respect of the dead body of the deceased Hira Naik, wife of Markonda Naik of a village Gunduri Jharana, PS Handapa district Anugul, and I found circular depressed communicated fracture over left side of the frontal bone and above lateral side of the left supra
Orbital margin.
margin and formation of
Dural hemorrhage.
I found the following external injury on the dead body of the deceased: one circular laceration of a size 1/2 into 1/2 into 1/2 just above a lateral side of the left eyebrow. One abrasion of a size 1 inch into 1 inch just lateral to left eye and a 2 inch
Anterior to left tragus.
Left tragus, multiple sample abrasion over right
Small
half of
abrasion.
multiple small abrasion over right half of upper lip, one abrasion of a size 1 inch into half over left side of a face, one half above left angle of a mandible, one observation of a size 1 inch into half over right side of a face, half lateral to right dorsum of nose, and a 1/8 inch below right lower eyelid, multiple larger abrasion over right arm and forearm over both
Forearm.
forearm over both
Dorsal and ventral aspects.
Multiple liner abrasion over right side of our back. The cause of death is traumatic head injury leading to coma, and the nature of death is homicidal. All the injuries are antemortem in nature. The nature of a weapon used is hard and blunt weapon with rough surface. The time since death at the time of autopsy is 12 to 36 hours. This is my report marked as Exhibit 6, and this is my signature on its marked as Exhibit 6/1. Cross examination.
So this is confirmed that he has died. He has died a homicidal death. So now you come to your you wanted to place PW12, the witness to the extrajudicial confession. Okay.
Page number 49.
Yes, PW12.
I am the informant of this case.
Yes.
The accused is the husband of my elder sister, namely Hira Naik. Hira Naik died 3 years back. The marriage of accused and my deceased sister was solemnized 17 to 18 years back. There was a quarrel between the accused and the deceased after marriage, and we had pacified the dispute many times. On the date of occurrence, about 7 p.m. to 8 p.m., the accused intimated over phone to me regarding missing of my sister Hira. On the next day morning about 7 p.m. myself and 7 a.m. myself and my other villagers reached the village of accused. The accused was present in his house, and on being asked, he confessed before me that he had killed my sister, myself, and others. Along with the accused, who proceeded to the spot, that is the Baduri Khola Jangala. We saw the dead body of my sister. There were 3 big stones pieces were kept on the dead body. I lodged FIR, and this is the said FIR already marked as Exhibit 1, and this is my signature of the mark.
Some villagers had gone with this man. So who are those villagers?
Villagers are the petition.
Susila Naik, Prafulla Naik, Pramod Naik.
The Prafulla Naik.
How they have been examined, na?
Exam only.
आपको एग्जाम करानी ये प्रोसीजर
सुशीला PW1
ଏମାନଙ୍କୁ ଭିତରୁ କିଏ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି? ସୁଶୀଲା ନାୟକ କେତେ? Deposition
PW1.
PW1. ଆଉ ତାପରେ
ସୁଶୀଲ ନା ସୁଶୀଲା? ସୁଶୀଲ ନାୟକ।
ପ୍ରଫୁଲ୍ଲ?
Prafulla has not been examined.
Not examined. ପ୍ରମୋଦ?
Pramoda PW11.
PW11. ତାପରେ ରଘୁ?
Pramoda PW1.
ବିଜୁ ନାୟକ?
Biju Naik has not been examined.
ଅଇଁଠୁ?
Not examined.
Suppose out of so many persons he is named, 2 persons have been examined, 1 and 11. Have they stated also about that the appellant made extrajudicial confession? ଏକ ନମ୍ବର ଆଉ 11 ନମ୍ବର ସାକ୍ଷୀ କହୁଛନ୍ତି କି ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ବିଷୟରେ କହିଛନ୍ତି? ଆଚ୍ଛା, we'll go to that. Okay, you finish it off. This come to the paragraph number 2, page number 50.
Proceed. Police held inquest over the dead body and prepared inquest report. This is the said inquest report already marked as Exhibit 2, and this is my signature on it marked as Exhibit 2/3. Police seized blood-stained sari, blouse, and a saya of a deceased in my presence and prepared seizure list. This is the said seizure list already marked as Exhibit 4, and this is my signature on it marked as Exhibit 4/2. Police seized blood-stained earth and sample earth in my presence and prepared seizure list. This is the said seizure list already marked as Exhibit 3, and this is my signature on it marked Exhibit 3/2.
Yes.
Cross-examination. I do not remember the date of occurrence. I cannot say the phone number from which the accused intimated the occurrence to me prior to the alleged occurrence. 3 to 4 times report were lodged before PS regarding quarrel between the accused and the deceased. I cannot say the name of a scribe of FIR. FIR was written at a PS as per my. The contents of a FIR was not read over and explained to me. ସୁଶୀଳା ନାୟକ, ପ୍ରଫୁଲ୍ଲ ନାୟକ, ପ୍ରମୋଦ ନାୟକ, ରଘୁ ନାୟକ, ବିଜୁ ନାୟକ, and Ointu Naika of a village Madhupur accompanied myself and the accused to the spot of occurrence situated inside the Boduri Khulla jungle. The said persons are my neighbor. Based on the quarrel between the accused and the deceased, the said persons had no good relationship with the accused. The distance between village of the accused and the spot of occurrence, that is jungle, is about 15 kilometers. The said spot was dense forest,
Dense forest and mountains.
dense forest and a mountain. One can die by falling from the said mountain. I cannot say the name of the persons who were present while the accused confessed his guilty before me. I have no direct knowledge on the alleged occurrence. I do not find the seized articles in the court hall today. It is not a fact that the accused has not committed murder of the deceased and that the deceased died on or from the mountain and that I am deposing falsehood.
All right. So the other two witnesses to the extrajudicial confession are, you said that 1 and 11, right? So you come to 11, PW 11. Then we'll go to PW 1.
PW 11 is hostile.
Yes, perhaps not supported.
PW 11 is the
All
hostile
right,
witness.
hostile witness. All right. Now you come to PW 1.
It's number 27.
Yes.
The informant is my cousin brother. I know the accused present in the dock who happens to be my Bhinoi. Deceased Hira Naik was my cousin sister who got married to the accused about 18 years back. The occurrence took place about 2 years back at a
Any issue out of wedlock?
No, there is no issue.
No issue.
No,
ଆରେ ମାନେ 17-18 ବର୍ଷ ହେଲାଣି ବାହାଘର ହେଇଥିଲା, କିଛି ପିଲାପିଲି ଅଛି କି?
Yes, Lordship,
କିଛି ନାହିଁ, ଏଭିଡେନ୍ସ ନାହିଁ ସେମିତି କିଛି? ଆଚ୍ଛା, ହଉ ଠିକ ଅଛି, ପଢନ୍ତୁ।
Years back at Budurikhulla jungle on the date of occurrence at about 2 a.m. accused Markanda informed the informant Gautama over phone that my sister Hira was missing, so later replied to go in the morning. In the morning, Gautama revealed about the same to me and our other relations. I, along with the Poda, the father of a deceased Prakash Nayak, PW2, Prafulla Prakash Naik, PW2, Prafulla accompanied Gautama, PW12 informant, to search Hira and reach the house of accused. The accused was present in his house, being inquired about her. He confessed to have killed Hira and led us to the spot of occurrence. That is the Budurikula jungle. Two villagers and a Gramorokhi of the village of accused also accompanied us. We found the accused had buried the deceased and covered her body with a big stone. The accused moved that stone and we found the dead body of Hira having bleeding injury on her nose and face, and by that time also it was bleeding. The teeth of her deceased were broken and there was injury at the back of her head and other parts of her body. The earth was smeared with blood. It appears that the injury was created by stone. It is revealed by the accused that the quarrel ensued between them when he asked for
Change
change
coin.
coin from the deceased at the time at the temple, and being enraged
Enraged.
he killed her. Gautama lost the FIR at his instance. I scribed the FIR Exhibit 1, wherein Exhibit 1 by 1 is my signature with the endorsement. I, along with the other, including the accused, were present at the spot. When police reached there, police conducted inquest over the dead body. In my presence, Exhibit 2 is the inquest report, wherein Exhibit 2 by 1 is my signature. In my presence, police collected blood-stained earth and a sample earth at the spot and prepared seizure list Exhibit 3, wherein Exhibit 3 by 1 is my signature. I was examined by police in this case. The accused and his wife were frequently quarreling with each other, and the deceased used to come away to her father's house, and again the matter was being resolved, and she was led to her husband's house. Cross-examination by the defense. The house of the accused is about 10 kilometers from our village. The house of Gautama and my house is situated in the same village. We left our village about 6 a.m. and reached the house of accused at 7 a.m. 10 days prior to the occurrence, I, along with my friends, had been to the house of the accused to meet my sister, and we were well behaved and received hospitality. At that time, my sister was all right. I inquired the accused about my sister and also dealt a Lathi Blue. Visay Nayako, Madano Nayako. Madan Naik is the PWC exam, PW6 the examination. VC Naik has not been examined. And Sanjay Pradhan of the village of accused were present. He confessed about his guilty. The place of occurrence is about 2 kilometers from the house of the accused inside the jungle. The aforesaid villagers of the accused also accompanied us to the spot. We reached there at about 8 a.m. The feet where the dead body was found was of size 7 feet into 2.5 feet x 3 feet. We found bleeding injury at 4 places of her body. Besides, all her front side teeth were lost. I have not been examined by the police in this case. Thereafter, I deposed in the court today for the first time, and prior to that, I had not revealed about the incident to anybody. It is not a fact that there was no such occurrence, nor I had been to the house of accused, nor accused confessed to have killed his wife, nor led us to the peaceful places of occurrence, but
Yes,
at
sir.
the instance of the informant, I am deposing falsehood.
So
The
these,
PW
uh, as you said, there are three witnesses to the extrajudicial confession. One is PW1, the other is PW11, and the third is PW12. Right? 11 has not supported the prosecution. Two witnesses have supported this extrajudicial confession, PW1 and 12. So apart from extrajudicial confession, they have also stated that it is you who led them to that place where the dead body was lying, and the accused removed those stones and it was found that the dead body was there and lot of injuries were there also. So this is your conduct. Apart from extrajudicial confession, your conduct showing the dead body to these witnesses, PW 1, uh, 12 and others. Okay. So this is one piece of evidence. So how do you challenge? First, let us tell how do you challenge the extrajudicial confession? This is mentioned also in the first information report by the informant. So it's not that it was subsequently a created story, but the relationship is that the informant is your brother-in-law, and she has stated that how you made a telephone call to him, and then they reached there, and next day, and then you made the confession, extrajudicial confession. So it is not that it is made to the strangers, but to the near, very close relation. The ଶଳା ପାଖରେ ଆପଣ କନଫେସ୍ କରୁଛନ୍ତି ଏବଂ କହୁଛନ୍ତି ତ ନାନୀକୁ ମୁଁ ମାରିଦେଲି ଏବଂ ଏମିତି ପଥରରେ ଛେଚିକି ମାରିଛି, ତାପରେ ନେଇକିନି ଦେଖଉଛନ୍ତି ମଧ୍ୟ ଡେଡ୍ ବଡିଟା ଜଙ୍ଗଲ ଭିତରେ ନିଜେ ଇଏ କରୁଛନ୍ତି. So this is the evidence which has been adduced by at least these two witnesses. And ଯାହାଟା ସେ confession କରୁଛି ଯେ ମୁଁ ପଥରରେ ଛେଚିକିନି ମାରିଛି, that is getting corroboration from the evidence of the doctor, that is PW, who is that doctor? PW 13, who has conducted PM examination and noticed number of injuries on different parts of the body, and has opined that the cause of death was due to trauma on account of that head injury, which has led to coma, and it is homicidal one. So this is the evidence of these witnesses. Then you said that one witness has also last seen that is PW 3. So come to PW 3, let us see what's he has stated.
PW 3 the hostile.
PW 3, acha, here not supported. So that means last seen how you last seen evidence 9. So only evidence, that means the extrajudicial confession and leading to of these witnesses to that place, and coupled with the recovery, and some material has also come through the evidence of the informant that there was also previous quarrel between you and your wife, and many a times it has been pacified, and
Cross-examination that has not been.
No, is it a extrajudicial confession? You read it. The accused on being questioned admitted. What is the ingredient of extrajudicial confession? That is required, no? He must volunteer.
Specific to what?
how this thing come, this how do you meet it?
The extrajudicial confession is the exact word used by the appellant. That doesn't.
No, exact words means what? They have stated that you state that you have killed your wife. So there may be some discrepancies, but if the main thing remains the same, merely because but it is ସମସ୍ତେ କହୁଛନ୍ତି ଯେ ବା ଏଇ ଦି ଜଣ ଆପଣ ମାନିଲେ ଯେ you confess before them that you have killed. So question is, what my esteemed brother told to you that what is the requirement for accepting the evidence of extrajudicial confession. What is that evidence which is required under law so that the court can accept that yes, this is the extrajudicial confession. Apart from all those things that the extrajudicial confession is a weak piece of evidence and it is very easy to create such evidence. ଖାଲି କହିଦେବ ତ ମତେ କହିଲା ଏମିତି ମାନିଲା ମୋ ପାଇଁ ଦୋଷ ସ୍ୱୀକାର କରଲା very easy. So
see the deposition of PW4. What next day in the early morning, in my presence and presence of his mother, the accused confessed. So this is a kind of statement that he is giving voluntarily.
Yes.
But in the first evidence, he is saying that on being questioned, so it was elicited from him. Here it is voluntary.
Yes.
Would you follow? Next day in the early morning.
The first information which has been given to this informant by the appellant is that your sister is missing.
Yes.
Then ordinarily there used to be quarrel, and whenever there was quarrel, the deceased was coming to the house of the informant. That means to her father's place. So he said that yesterday your
Sister was
sister had
missing.
gone somewhere. So since she had not come to the house, that is how they
They
went in
suspected,
search
right?
of the right. So as it appears, he had not gone alone. He had gone with
Being accompanied by some
he had
villagers.
gone with so many persons as has been as is there in the cross examination of PW12. At least 1, 2,
Correct.
3, 4, 5, 6.
Hmm.
6 persons accompanied him. Apart from PW1, 11, there are other 3 persons
Yes.
or 4 persons
Yes.
who have not been examined. Okay.
Prakash
So-
examine ହେଇଛି କି? ହଁ, Prakash examine. I along with Padma,
Last
the
in
father of
PW5.
deceased, Prakash, Prafulla accompanied Gautam to search Hira. PW1 କହୁଛି informant.
प्रकाश नाटा ये कहनी अवश्य यो
PW12
PW12
କହିନି. ହଁ.
किंतु प्रकाश
Informant
Prakash Naik PW2.
2. ସେଟାକୁ PW1 କହୁଛି. I along with Pada is the father of deceased. Prakash Naik, Praful accompanied Gautam to search Hira and reached the house of accused. ତେଣୁ ପ୍ରକାଶ ବି ସାଙ୍ଗରେ ଅଛି, ଗୌତମ ବି ଅଛି.
That affects PW5 stated that in the early morning, both spouse, like other days, had been to jungle for work. But afternoon, the accused returned to village without his wife.
Yes.
with that
PW5. PW5. That is important.
PW5 that is the last
Yes. In the early
preparation
morning,
କରିବା
both the spouses, like other days, had been to the jungle for work, but the afternoon, the accused returned to village without his wife. Yes.
he did not
On our query, he did not disclose anything. So this is
Later on, confessed before
later on confessed. So it is a clear one.
So one thing, so last in evidence which you said PW3 the last is not the
is not
that is not
PW5. PW5.
cross examination form बाहर करचंदी.
I have not been examined by police in this case.
अच्छा अच्छा वो
What?
examination मान
I had not seen.
I had not seen अच्छा ठीक है. Again I have no doubt.
पूरा मना कर दो.
अच्छा ये गला
Completely.
completely not. ଆଉ ଅନ୍ୟ ସାକ୍ଷୀ ମାନେ କଣ କହୁଛନ୍ତି?
The mother of the deceased lordship, the PW9.
Again 6 also same. You come to PW6.
PW6.
In the alleged morning, both the spouses.
No. Hostile, but a different aspect. Hostility is not on this ground. That aspect has not been challenged in cross-examination.
In the alleged
Above
morning,
the
both the
matter
spouses, like
on our
other
brief,
days, had been to the jungle for work. But in the afternoon, accused
we are
returned to the
talking
village
about
without his wife. On our query, he did not disclose anything about the latter on ଛାଡ଼ନ୍ତୁ କନଫେସ୍ କଲା ବୋଲି ତ ଏ ପାର୍ଟରେ ଆପଣଙ୍କର କଣ ଅଛି?
କ୍ରସ୍ ସେକ୍ସନ କିଛି ନାହିଁ,
exemption lordship on
କିଛି ନାହିଁ,
will.
କିଛି ନାହିଁ।
I had not been to the forest with the police, but the LTI was taken. Police
ଫରେଷ୍ଟ କୁ ଯାଇନି ପୋଲିସ, ସେଟା that is different. Next day when police came to our village, accused admitted his guilt before police at all. While in police custody, disclosed to give recovery of the weapon. So he is also a witness to disclosure statement.
witness to seizure.
Disclosure statement as well as seizure. He put his LTI, ତେଣୁ ସେ prove ହବ ନାହିଁ।
One is then ତାହେଲେ ଏଇ evidence ଟା ରହୁଛି PW6 ର evidence last scene ଟା ଏଇଟା ରହୁଛି। ବାକି ଆପଣଙ୍କ 1 number ଆଉ 2 number ଏ ଯୋଉ accused confessed ଯୋଉଟା କଲା ସେଇଟା ରହୁଛି। ବାକି ଆପଣ ତାଙ୍କୁ ଲିଡ୍ କରି ନେଇକିନି ଦେଖେଇଲେ ଡେଡ୍ ବଡି ସେଇଟା ରହୁଛି। ଆଉ apart from that the doctor's evidence ଆଉ କଣ ଅଛି? 700 number ହୃଷ୍ଟାଇଲ ହେଲା।
SFSL ର କିଛି ମ୍ୟାଚ୍ କରୁଛି କି? Examination. Submitted text. ఈ రిపోర్ట్ రాసింది
No. So when he gave the information to the informant over phone that your sister is missing, since କାଲି ଦିନ 11টাରେ ରାଇଟ୍ ଫୋନ୍ କଲା କେତେବେଳେ ନା ରାତି 2টাରେ ଫୋନ୍ କଲା। ରାତି 2টাରୁ ଫୋନ୍ କରି କହୁଛି ଦିନ 11টাରୁ ସେ ମିସ୍ କରୁଛି ବୋଲି। ତ ତାପରେ ଏମାନେ ସବୁ ଯାଇଛନ୍ତି, ତ ଯାଇକିନି ତାକୁ ଯେତେବେଳେ ପଚାରିଛନ୍ତି ଏବଂ ସେ ପ୍ରଥମରେ ସେ ଜିନିଷ ଯେତେବେଳେ ଡିସକ୍ଲୋଜ କରୁନି, ଏତେ ଲୋକ ଗୁଡାକ ଯାଇକିନି ପଚାରିବାରୁ ଡିସକ୍ଲୋଜ କରୁଛି। ସେଠୁ ଏଟା whether it would be the extrajudicial confession which is the requirement of law. Have you examined in that line? Madam, we are putting you some question. We are giving you hint. We are asking you to just think over it. A man is telling to the brother-in-law that your wife is missing. Hey, my wife is missing. Your sister is missing. So that means he trying to, suppose he is aware that I have killed and he is trying to conceal. He is trying to misguide. So in that circumstances, the brother is also surprised why my sister has not come. Usually he used to come. So then he, along with the other co-villagers, is going to the house of the accused. And so many persons, about 6 to 7 persons have come. And they must have made a query to the accused that where is, so that is the surrounding circumstances under which this confession is made. So my esteemed brother pointed out to you that can it be said that it was a voluntary one? ଜଣେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ କରିବାକୁ ଏବଂ ସେଟା ଆଡମିସନ ହବାକୁ ହେଲେ ତାକୁ କଣ କଣ ରିକ୍ୱାରମେଣ୍ଟ ଦରକାର? କୌଣସି ଯଦି ଭୟଭୀତ ହେଇକିନି ତାକୁ କୌଣସି ପ୍ରମିସ ଦିଆଯିବ ଯେ ତୁ କନଫେସନ କଲେ ତାକୁ ଏତିକି ରିଲିଫ ମିଳିବ ହେଲା, ଏବଂ ସେଇଭଳି ପରିସ୍ଥିତିରେ ଯଦି ଜଣେ କନଫେସନ କରେ ତାହେଲେ ସେଇଟା ଗ୍ରହଣୀୟ ହବ କି? ନମ୍ବର 1। ନମ୍ବର 2, ଏଇ ଯାହା ବି ପ୍ରସିକ୍ୟୁସନ ଆଣିଛି ଯେ ଏଇ ଟାଇପ ର କନଫେସନ କଲେ ତେଣୁ how far that would be relevant under section 24 of the Evidence Act, which is of course now the
the PW1.
Yes.
It is in the evidence of the PW1. The Grammarakhi was present at also. The Grammarakhi being the police officer, he has not been examined.
Grammarakhi is not a police officer. In presence of
the
when you're making a submission, you must know the law. Are you aware that it has been held by a full bench of this court, and the Justice C.R. Das has written that judgment. That matter was referred to the full bench, and it was decided that Grammarakhi is not a police officer, so extrajudicial confession made before him is admissible. Are you aware about it? We search for that decision.
He has not been examined here. Grammarakshi has not been examined. But you see the whole conduct of the accused, how he is trying to avoid giving a misleading statement. That is also his conduct, because he is saying that your wife, your sister is missing. So he is trying to mislead the family members. And thereafter he is also confessing it before some people in different manner. Then 27. So all these things have to be taken. Your preparation should be on that count only.
When you are taking the persons to a place inside the jungle and showing the body, nobody would have the knowledge that the body is there. It must be within your special knowledge. So you are the person who knew that yes, there is the body of my wife, and it was under the stone, and so many injuries are there, and that is how you remove the stones and pointed to them that this is the body. So how do you explain that if this is the conduct? Because the circumstantial evidence, of course the principle is there that these are the things we have to see, that the chain of circumstance is complete, and it points to the guilt of the accused, and it cannot be, no circumstance can be explained under any other hypothesis, and all those things are there. But this is one of your previous conduct in quarreling and with the deceased, and even assaulting her on some occasion, and on the date of occurrence giving a misleading statement, then making confession, then leading to that place inside the jungle where under the stones the dead body was found, coupled with the fact that the doctor has stated it's a case of homicidal death, and one person at least has seen you and your wife, that is PW6, going to the jungle, and you are returning alone. Thereafter, nobody has seen the deceased alive. So from that jungle where you have gone, the dead body is recovered. So these are the circumstances. So get prepared in that light. You also get prepared. You see, is when you are getting a chance to argue a matter, the 302 in the High Court, and the matter is being live streamed. So many persons, students, the lawyers, they are watching your performance, right? So you are to show not only to the court but also to them that how you are uh, pleading, how you are arguing before the high court. So your performance, your preparation, the citation should be up to that standard. And when we are giving you the paper books for like the amicus curiae, or we are engaging, we expect that type of preparation from it. These are poor persons. They have no money to engage a counsel of their choice. So that is how this court is engaging and expecting that type of performance. Because if you commit negligence in the preparation, okay, the person may be that life imprisonment may remain. So the assistance should be of that standard, right? And really, because you are in the state side, it should not be your duty, sir. The conviction should be upheld. No, you must also point out if there is any point in favor of the accused, you should bring it to the notice of the court. Okay, because we are just passing, going through one by one. So whatever observation we are making now, that is not the final. We may change it. So that is all. It's just a discussion like that. We are giving you hint. You prepare in that line. Come prepared with the books and argue the matter. Right. So Miss Dei, we are keeping this matter to tomorrow. Get prepared accordingly. Go thoroughly to the each of the evidence again and again. Okay, and see the citation. We want you should come with some citations on different points on extrajudicial confession, last scene, how it is to be accepted. All right, and conduct all these things. You come prepared. Tomorrow we'll take up this.
Hon'Ble, you made a